the decision or the resolution of Parliament, of the NCOP and the NA, and remitting the framework back to the committees, if the 1st of May would continue anyway. And maybe coupled with that, whilst you're answering that question, the question is, what is the point of the elaborate process of having that is provided for, the process provided for in the PFMA, the Money Bills Act regarding the tabling of the annual budget and the fiscal framework, and it being adopted if at the end of the day the 1st of May continues anyway?
I think that's a very good question, and that's one of the reasons we say Section 7.4 is unconstitutional, because even after Parliament expresses in the fiscal framework that it rejects a VAT increase, it will come into effect nonetheless. But to answer your question, that's why we challenged both. The effect of setting aside Parliament's decision on the fiscal framework will be to restart the budget process. So it will then not have adopted the fiscal framework. It will have to go back, debate the fiscal framework, and adopt lawfully a new fiscal framework. And after that, the process of the Money Bills Act can follow, the Revision of Revenue Act, the Appropriations Act, and so on. So that's the effect of that part of our case. But I understand this is not the EFF's position, but it's our position that will not stop the VAT increase. That's why we've asked for the other part of the relief, which is to suspend the announcement. And the reason we asked for the suspension of the announcement is because the power given to the minister is an unconstitutional power.
I'm still not clear then, what is the point of the elaborate process that the legislation provides for the tabling of the annual budget that includes the fiscal framework, and in this instance, that includes the proposal for the VAT increase? What's the point of all of that if the parliamentary process has absolutely no effect on the announcement by the minister?
I think the problem, lady, is that there's a disconnect between the budget process in the Money Bills Act and Section 7.4 of the VAT Act. You could rewrite Section 7.4 of the VAT Act to say the announcement is in place until or unless Parliament rejects it in the fiscal framework. But that's not what Section 7.4 says. It requires legislation. So unless and until Parliament passes legislation, that announcement will be in effect. So I agree with you that there's a problem here, that the process, at the first point where Parliament decides on the appropriateness of the VAT increase is when they vote on the fiscal framework. But that doesn't affect the announcement. It's also possible under Section 7.4, the Minister could have said the announcement would come into effect on the 1st of April, before Parliament even had an opportunity to vote on the fiscal framework. So I don't see these as problems with my case, lady. I see these as reasons why Section 7.4 is problematic.
But 7.4 is not untethered to the annual budget.
Yes, that's correct.
So that provides some grounding in a way. It can't just come out of nowhere.
That's correct. Yes. Just to round up on these opening remarks, and to address the question you raised, my Lord, the argument that the DA is only here because they've lost in Parliament. Our case is that we didn't lose in Parliament. Our case is that Parliament followed an unlawful process and did not take a lawful decision about the fiscal framework and therefore about the VAT increase. So we said we didn't lose in Parliament. That's why we're here. And then if I can then turn to the VAT decision. And I just wanted to emphasize quickly what we said, 3 important facts, which are common cause, and that determine the outcome of this case. Intended the VAT increase and the power in Section 7.4 is to raise revenue. It's not to regulate behavior. And that appears from the Minister's answering affidavit, paragraph 45, page 03-23. He says that the increase reflects my best judgment on how to raise the revenue required to fund public goods. There's no argument is made that this is a regulatory change. And this will become very important when we look at the case law. The second is that it's common cause that it is not possible to repay VAT to consumers. So the VAT that consumers, you and I and everybody in this room, will start paying on the 1st of May when we go to the grocery store, when we pay our bills, can never be returned to us. It is not possible to return that money. It will be forever in the National Revenue Fund. And that's because of the nature of that. because it's paid by the consumer to the vendor, from the vendor to SARS. And so SARS will know how much the vendor had paid and can return money to the vendor. But how does the vendor give it back to the Pick and Pay, give it back to the thousands of people who came shopping? So, oh, I owe you R3.22. I owe you R4.76. It's not possible. It won't happen. And that's again accepted by the minister.
Well, what happens if there are emergencies that require some reaction from the Treasury and the minister at the point in time? Isn't Section 7.4 designed for that? That when it is needed and there's a demand for the alteration to take place because the country needs it, and the parliamentary process is taking too long. Wasn't that 7.4 designed for that eventuality?
Yes, so thank you, Lady. There's a few answers to that. The first is the point that Justice Savage raised, that it can't be for an emergency because it can only be once a year at the taping of the budget announcement. If there's a shortfall in August, you can't use Section 7.4 to suddenly raise that and increase the revenue. So it's part of a long-term planning process, not part of an emergency revenue-raising process, because it's linked to the budget. That's its purpose. So that's the one part of the answer. The other part is that it's true that in the past, when Parliament has considered a budget, it takes many months to do it. But if Treasury says, and the Minister of Finance says, we urgently need this money, I have a cash flow problem, I am not going to be able to pay salaries in 2 months, I need more money, the only way I can do it is VAT. He can table a money bill to increase the VAT rate by amending Section 7.1 and ask Parliament to deal with it urgently. And there's no reason why Parliament can't act within a month or two.
So
or even quicker if they need to.
What's the purpose of 7.4?
It's a good question.
Because 7.1 is there that states what the rate is. But what is the purpose of 7.4?
I think that the purpose as the Minister defines it, he talks about financial flexibility and stability. So what he's saying is, from the time I propose the budget, I need the revenue to raise as I proposed it, because that's how Treasury has planned it. But Treasury doesn't have to operate that way. Our budget doesn't have to operate that way. We've given references to various other countries that don't work this way, where VAT is not raised by the executive, where VAT is raised only by Parliament. And those countries operate perfectly efficiently. Ireland, Germany, New Zealand, Australia. They all manage without this power. So I think the power is...
But Mr. Bishop, you must concede there are also countries that work like us.
Yes, that's correct.
And there's nothing wrong with that either.
Well, my Lord, whether there is or not is a question of constitutional law,
Yeah, but
peculiar to each country. We say, for the reasons I'll get to, that under our constitution, there is a problem with it. But yes, I accept there are other countries that have similar provisions. A lot of them are a lot more limited than ours. Ours is exceptionally broad, and I'll get to why. So maybe the second fact I wanted to stress was that it's impossible to repay. And the third, which is one that I mentioned previously, is that Parliament has, at best, not lawfully endorsed the VAT increase.
So can I just go back to impossible to repay?
Yes.
And maybe connecting that to the issue of harm for now. I'm not going there yet. Isn't the money going to the National Revenue Fund for the purposes, for the benefit of the public? So when you say repay, isn't that at least the money goes to the benefit of the public? It's not necessarily lost.
So yeah, that is an argument the Minister makes. And effectively the argument is that this tax that I've imposed is justified because it is a tax. Because that's what happens to taxes, is they go into the National Revenue Fund. That's the definition of a tax under Shuttleworth and Casino Association or Cloud. So he's saying, because it goes into the National Revenue Fund, therefore it's justified. But that means that every executive tax will be justified because it goes into the National Revenue Fund and is used for the common good. But the other answer, my lady, is there's a difference between me having however much I would spend on VAT in the year that the increase would be in place. Let's say I spend it's money out of my pocket. Yes, it will go into the National Revenue Fund and it will be spent on other goods, but I won't have the money. And that's a harm when the decision to take that money from my pocket and put it in the National Revenue Fund is taken by somebody who doesn't have the lawful power to do it.
But how will that change if for instance, Parliament introduces the VAT?
No, the DA has no problem with Parliament voting for the VAT increase. If Parliament does it, then that's a choice that Parliament has made. The Constitution gives them the power to do it. Our objection is to South Africans being taxed unlawfully. We don't have an objection to South Africans being taxed lawfully. So, maybe just to refocus, so I'm dealing with the VAT challenge. I'm going to start briefly with what we're here asking for suspension. It's interim relief for asking for suspension. We say the test is the EFF versus Bourdain case. Is it just and equitable? I'm not going to take the court to it, but the reference in that bundle is page 70, paragraphs 113 to 5. And what Justice Jafta there says expressly is this is a lower test than OTA. It's not the OTA clearest of cases case. When one asks for suspension, it's just what is justice and equity. I'm not going to make too much of this because ultimately the consideration the court will have to consider whether it's under an interim interdict or suspension are largely the same. The court must look at the prospects of success and must weigh the harm of granting versus the harm of refusing. We just think that the test is lower when this court conducts that exercise. But that's as far as the submission goes. So that then goes to the first issue, which is what are the DA's prospects of success in Part B, in its constitutional challenge to Section 7.4. And I want to start by looking at what does Section 7.4 mean, how does it operate. I'm then going to argue that the Constitution, as an absolute rule, does not permit Parliament to delegate taxing power to the executive, and that the case law is crystal clear on that. And I'm then going to deal with why the court, when it weighs the harms on either side, should sustain the minister's decision. So to begin with the Section 7.4, as the court is aware that the rate is set in Section 7.1. There are other tax statutes where the rate is not set in legislation. It's set in schedules or it's set in regulations. That is set in the Act itself. So how does Section 7.4 operate? The first point, which is one that Justice Savage made, is that it can only be done at the budget announcement. So that's the trigger for the minister's power. And the minister makes much of this, and he says, oh, this shows what a public announcement it is. I must do it in Parliament. Everybody will know about it. And that's true. But the other reality about it is that there will be no public process before the announcement. No participation, no draft put out for public comment. The minister announces it, and then it comes into effect on the day he says. It could be the next day. And so this is actually even worse in the sense of what happened in New Africa and Casino Association. In both of those cases, information about the regulations before they were enacted, and those regulations changed the tax rates and were then challenged. But at least there was a regulatory process of public participation. Here, everything happens behind closed doors in Treasury. And then is announced and comes into effect whenever the minister says so. So the second point I want to make is that what Section 7.1 says is that the VAT rate specified in this section is to be altered. So that's a reference back to Section 7.1. So it says in express terms that what is being altered is 7.1. That's what Section 7.4 says. The minister is given the power to alter the VAT rate in Section 7.1.
Does that amount to an amendment of Section 7.1 in the sense that when the minister says this is a temporary power that is exercised and pending the enactment of legislation by Parliament, if legislation is not introduced, then it automatically lapses. That's what the minister says, and then we revert back to what is actually in 7.1.
So I must accept, maybe, that it's temporary, and I'm going to get to just now exactly when the period would lapse. But so I accept that it is temporary. But the minister, in the next announcement, could make the same alteration that would be in effect for another 12 months and another 12 months. So he'd have to keep doing it every 12 months. But I accept it's temporary. I submit it is an amendment, because it may be a temporary amendment, but it's still an amendment. Because, and I'll explain now why, the only way to undo it is to amend, for Parliament itself to amend Section 7.1. But whether it's an amendment or not is not central to the DA's case. Because we say, well, the problem here is that it's a power to impose a tax. And whether that's done through an amendment to the statute or through schedules or regulations, the Constitution prohibits it either way. It's worse because it's an amendment to the statute itself. But I don't have to win that fight to win the challenge to Section 7.4 about is it technically an amendment or not. So that's my answer there. If we then look at the question you're asking about when will it lapse? So what the text says is, subject to Parliament passing legislation giving effect to that, so it's in effect for 12 months, subject to Parliament passing legislation giving effect to that announcement within that period of 12 months. So it seems to me that there's various possibilities that can happen in those 12 months. So the one possibility is that Parliament passes legislation that gives effect to the Minister's announcement. So it passes legislation giving effect to the 0.5% increase. Then the announcement will lapse because it will be replaced by the amendment to Section 7.1. The other possibility is that Parliament passes legislation with a different increase, a 0.1% increase or 0.25% increase. Then it will also, the announcement will lapse on the date that law comes into force, because it will be replaced by the new change. But there's two other possibilities. If Parliament does nothing, so it doesn't within the 12 months vote at all on an amendment to the VAT Act, then it's in force for the full 12 months. I think that's very clear from the text of the statute. I think the more difficult question is what happens if Parliament, the Minister puts up a money bill before Parliament proposing the VAT increase, and Parliament does not adopt it. So it either doesn't adopt the Act at all, or it removes the amendment to Section 7.1, and then adopts an Act without any VAT increase, but with other changes to the VAT Act. What does that mean? And I think it's very uncertain whether what the case is then is whether it would continue for 12 months, or if it would lapse on the date that Parliament implicitly rejected the increase. But
isn't the latter more sound?
I think the latter is more principally sound, but it's not consistent with the text, is the problem. Because what it says is that subject to Parliament passing legislation, giving effect. So, but I don't think this again is vital to my case, because whether it's in place for 4 months or 8 months or 12 months, it's still unconstitutional. But that's our view on how Section 7.4 operates. But I think what's important about this analysis of Section 7.4 is the only way for Parliament to really stop the announcement is for it to amend Section 7.1 itself, either to adopt the Minister's rate or some new rate, or to, I suppose they could amend Section 7.1 and impose the same rate again. That would stop it. But they have to amend it to get there. So maybe that's how Section 7.4 operates. I now want to get to what's really the core of this part of our case, which is that Parliament cannot delegate its taxing power. And we submit that this is a fundamental and absolute principle if one looks at the cases. And I want to take the court through these cases, because what they say is that there's certain powers in the Constitution that are expressly assigned to certain bodies. And when the Constitution does that, those powers cannot be delegated. So the Justice Alliance of South Africa case is an example. The power to determine the Chief Justice's term is given only to Parliament. It cannot delegate that power to the President. Taxing is the same. So if the court can go to that bundle, and we'll start with Fetscher, which is really the source of this. So the issue in Fetscher was really about whether a decision by municipalities to impose rates as part of its budget was administrative action or legislative action.
Where will we find Fetscher in this bundle?
The part I will take you to is at page 94, which is paragraph 45 of Fetscher. And this is where the court says, it seems plain that when a legislature, whether national, provincial, or local, exercises the power to raise taxes or rates, or determines appropriations to be made out of public funds, it is exercising a power that under our Constitution is a power peculiar to elected legislative bodies. It is a power that is exercised by democratically elected representatives after due deliberation. So that's really the founding source for this argument. And then there's 4 cases that come after that. And I'm conscious of time, so I'm going to go through them fairly quickly. But the next one is Shuttleworth. So Shuttleworth is a bust. Mr. Shuttleworth, you had a windfall when he sold his company and made, I think it was 2.5 billion rand that you wanted to take out of the country. And SARS says, well, if you want to take it out of the country, you've got to pay 10% in terms of the customs and excise tax. And Mr. Shuttleworth argued that that rate, that 10% rate, had been unlawfully set because it was a tax and it had been delegated from Parliament to the President to the Minister, and that was unlawful. And what the court, this is page 237 of the bundle, paragraph 22, is it endorses what was said in the Fetch rate. So what Moseneke ECJ says is, a blissful starting point would be to affirm that the power to tax residents is an incident of and subservient to representative democracy. The manner and extent to which national taxes are raised and appropriated must yield to the democratic will as expressed in law. It is the people, through their duly elected representatives, who decide on the taxes that residents must pay. An executive government may not impose a tax burden or appropriate public money without due process and express consent of elected public representatives. That authority, and indeed duty, is solely within the remit of the legislature.
Does 7.4 not do that? Does 7.4 not do that by within the 12-month period having Parliament consider the increase?
For two reasons, no. Because the VAT increase is immediate and irreversible. So it comes into effect before Parliament acts, and it cannot be undone after Parliament acts. It may be different with other taxes like the income tax, because I'm not here arguing about the Income Tax Act. I'm just saying that is the worst example that you can think of. But with the Income Tax Act, if there was a similar provision, and Parliament eventually does not amend the Income Tax Act, people can either withhold the tax because it hasn't become due yet, or they can get a refund from SARS. But it's just not possible with that to repay the money. And so that's what makes that unique here when it comes to these types of provisions that provide for executive action and parliamentary action.
So do I understand you correctly? You are saying that even if Parliament has oversight over the minister, that's after the fact, and the tax rate cannot be undone.
Yes.
Parliament might change it, decrease the percentage, but the amount that was announced by the minister stays for that period of time until Parliament changes it.
Yes, and it can never be undone. The money can never be repaid to the residents. And they would have paid a tax imposed without the duly elected representatives having had any say in it.
But Parliament agreed to this legislation.
Well, no, that can never be a reason why legislation is constitutional. You can never say, well, Parliament adopted it. Our whole point is that Parliament does not have the constitutional power to delegate its taxing power to the minister. So with respect, that the minister makes that argument, but it's not an answer. So how does Shuttleworth comes out, the case comes out against Mr. Shuttleworth? Why? Because the court says there's a difference between regulating behavior and imposing taxes. It says Parliament can delegate the power to regulate behavior, but not the power to tax. And it says what's going on here with imposing charges on taking currency out of the country is a regulatory measure, because what you're trying to do is prevent Mr. Shuttleworth and other billionaires from taking their money out of the country because that's bad for the rand. And so it's a regulatory measure. And therefore it could be delegated. But Shuttleworth affirms the principle in Fetcher. We then get New Africa, which everybody gets very excited about. But New Africa is exactly the same as Shuttleworth. It's exactly the same
Well,
case.
not according to the minority judgment.
Well, with respect, it's two judges, Judge Rogers and Judge Culliton. They sort of have no binding precedent.
I know that, but their reasoning looks to be sound.
But their reasoning was not adopted by the majority. And so with respect, this court is bound by the majority's reasoning, which is very clear. And the majority's reasoning is exactly the same. It applies Shuttleworth. This is at paragraph 105, where it quotes paragraph 48. It says, the question is it a tax or is it a regulation? And it concludes that the issue there, remember that the issue in New Africa was about diplomats buying alcohol and cigarettes and then selling them on. So, and the changes are made to regulate the behavior, to stop the diplomats taking advantage of this loophole and stop them not paying the VAT and customs duties that they should pay. And
But if you look at it narrowly, in terms of the broader scheme of the VAT Act, holistically, isn't the minister just regulating the VAT percentage-wise?
Well, it's not about whether you're regulating the rate, it's about are you regulating behavior? Are you trying to influence the way that people act? So there may be other parts of the VAT Act which would be regulatory in nature. So if you change what was zero-rated goods or you change the exemptions, you're trying to get people to donate more money to charities, to buy certain goods and not others. Not this case, but that may be regulatory.
But doesn't it regulate our behavior, becoming poorer?
Well, it regulates our bank balances. I'm not sure it regulates our behavior. Because we still have to go and buy the goods and services that we need. We're just going to have to pay more for them. And this case is not made by the minister. The minister never says in his answering affidavit, this is a regulatory measure. He says the opposite. He says this is a revenue-raising measure. His whole defense is we need the money, not we need to stop South Africans doing X, Y, and Z. It's common cause, this is a tax.
Yeah, but the minister also says that in certain circumstances, the plenary powers that he's got is not unlawful because it's limited and Parliament has got oversight over it.
Yes.
So it's not as if he goes on his own and do things that's not within the purview of Parliament. It's not similar to the Smith matter, where the drugs and cannabis was sort of looked at.
Yes. So our answer to that, Mulder, is it's not relevant if it's a tax. This question, the New Africa test they said, where they say we're delegating plenary powers and it might be lawful, we've got to consider all these factors. That's relevant if it's not a tax. But for cases from Procedural through Shuttleworth, through New Africa, through, I'm going to get the Senior Association will talk about crystal clear, that once you find it's a tax, it cannot be delegated. You don't get to any other question. Parliamentary oversight, irrelevant.
But is New Africa also not, in the true sense of the word, a tax? Schedule has been changed, and therefore those people that wants to buy alcohol duty-free must now pay more for it.
Well, that's what Mr. De Beer argued in front of the Constitutional Court, and that's what the Constitutional Court held was wrong. Because he was representing one of those. Yeah. He was representing New Africa. Mr. Mkiwa was representing SARS. So what the court says in paragraph 110 is which is at page 185 of the bundle, is he says what one gleans from the long title is that the Customs Act mandate was to control the importation and use of certain goods. In this matter, the minister highlighted that the primary reason for the amendment was to curb abuse by diplomats. This in turn informs us that the charge is in fact regulatory in nature. One can disagree with the court's assessment of that, but that's the reason that he gives for upholding it. He says it's regulatory, therefore it didn't need to go through the manifold procedure. And that's the Russia dissidendi of the case. So, and that's then applied in casino association. So New Africa happens in 2023. In October, the next month, November 2023, we get casino association. And what's fascinating about this is it doesn't even cite New Africa. It cites Shuttleworth and Fletcher. And it says, it quotes Fletcher, it says the same thing. This is paragraph 42, bundle page 29. It is settled that the power of taxation.
So you're going too fast for us.
Yes, please. Slow down a bit, Mr.
Bishop.
I'm so nervous about time. It's page 29 of the bundle.
Yeah.
Paragraphs 42 to 43. And what Mkhoka AJ says is, it is settled that the power of taxation and appropriation of government funds are reserved for legislature, and that the executive has no power to raise taxes itself. And then it applies the test in Shuttleworth. It changed it slightly because it says you must focus not only on the dominant purpose of the statute, but whether the charge has a nexus to the regulatory scheme. But that's not really relevant here. Ultimately, what it concludes is that this is also regulatory, not a regulatory measure. It says this one here, this power to change the gambling levy. And I want to emphasize this because the gambling levy was imposed by the Northwest Act. And then the minister is given the power to set the rate. It says that power is the power to raise a tax, and therefore it's unconstitutional. It doesn't engage, after New Africa, in any of these questions about balancing plenary powers and when is it possible. It says it's a tax, end of story. And the court reaches exactly the same conclusion a year later in Muklaba. Muklaba is a case about provincial legislation that affords traditional leaders the power to impose traditional levies on their communities.
So if I understand your argument by referring to all these cases, you're saying that we must look at the dominant purpose of the Act. And if one with regard to 7.4, it's simply clearly to raise tax,
Yes.
not to regulate conduct.
And once you reach that conclusion, it is unconstitutional without more. Yes, that's what the cases say.
Is that you mean your case is so simple?
Yes, very simple.
Mr. Bishop, is the tax not raised in 7.1? And then for purposes of Muklaba and Casino Association, that's where the raising takes place. And therefore the amendment to the rate that occurs in 7.4 is something different.
Yes. So this is an argument that's raised by the minister. So I've already explained, I think that's inconsistent with Casino Association, because the same structure was in Casino Association. It was set in one section, the power it was imposed in one section, and the power to amend was given in another section. It's also inconsistent with Fetcher, because in Fetcher, this is page 95 of the bundle, paragraph 46. The court, just after it says what I read out to you about the democratically elected legislators can impose taxes, it says that the argument of the challengers there was that the resolution had none of the ordinary characteristics of legislation, and that the levy was not of general application, applied for a limited period of time, and did not have to be promulgated. We have already decided that the resolutions to adopt the budget were not administrative actions, and then this is the important part. The resolution of the TMC taken for the purpose of raising the levy and paying the subsidies formed an integral part of the adoption of the budget, and as such constituted the exercise of taxing and spending powers. Such powers are constitutionally vested in the legislature in their exercise of forming not administrative actions. So even though it's temporary, and Casino Association says even though it's imposed in another section when you change it, and one can just think about it logically, that the minister could, under 7.4, decrease that to 0%. He could raise it to 100%. And I think it would be strange to say that when he did that, he was not imposing a tax or undoing a tax.
So you're saying we don't need 7.4 at all?
No, it should be. That's when we have case in part B. It should be struck from the statute completely, yes. That's the case.
So what happens if there is, what contingencies are there in place when there is a need for the minister to intervene at a point in time?
He must ask Parliament to pass legislation urgently to amend Section 7.1 of the VAT Act.
I mean, going back to my initial question, isn't this a recognition that those processes take too long? And so Parliament recognized that by introducing 7.4 to say that for an interim period, with these conditions, we are going to give you this power. But this power is not absolute, because at the end of it all, we have the power to change, to alter what you've actually put, but you're just putting this for this period.
My first answer, ladies, is that whether it's convenient or useful or expedient is irrelevant, because Parliament doesn't have the power to do it. It may be good policy, but the law that the Constitutional Court has said is that Parliament cannot delegate the power to tax. I still want to get to Muklaba.
Yes.
Yeah. But that's the first part of my answer. The second part said there's many other countries that don't need this. This isn't universal. The third is this is not an emergency power because it's linked to the budget. So it's part of the planning process. And the third is it may be true that Parliament thinks this takes too long, but that's can never be a justification for delegating their taxing power, saying we're too slow, therefore we're going to ask the minister to do it. The solution is for Parliament to act more swiftly. And the Constitutional Court has said, for example, in Doctors for Life, that when Parliament needs to act urgently, it can and it must.
But if one have regard to the constitutional scheme currently, it's only the Minister of Finance that can introduce a money bill.
Yes.
No other member of Parliament may do it.
Yes, that's another problem with Section 7.4, because the minister controls what gets in front of Parliament and controls when it gets in front of Parliament. So
even if the parliamentarians shout and scream about the VAT rate, they can't introduce a bill or money bill to saying we can have one to lower it. They have to wait for the Minister of Finance.
Yes, and if the current Minister of Finance won't do it, they can always get a new one. by electing a new government. But yes, those are the only powers that Parliament has. No, I didn't mean that facetiously. I mean that's Parliament's power.
Is your client so eager to be
Exactly.
to take over Parliament?
But that's the lever that Parliament has, because you're right, Parliament itself cannot introduce the bill. It must wait for the Minister of Finance, or if it's so upset with the Minister of Finance for not introducing a bill, its only remedy is to a motion of no confidence in the Cabinet. That's the constitutional scheme. I'm not talking about politics. I'm not a politician. I'm a constitutional lawyer.
I'm just saying. But as my learned colleague, presiding judge, indicated, isn't that the reason why Parliament has introduced 7.4?
I'm not sure that that's a reason for 7.4, because without 7.4, the Minister can still introduce a money bill to amend the VAT Act at any point in the year if there's an urgent need to raise cash flow and ask Parliament to deal with it urgently. It cannot be, I would submit, that Parliament says we sometimes take a while to deal with legislation, therefore we're going to delegate this core power it's called democratic power to the executive, when there's no legal reason why it cannot act swiftly, and there's no practical reason why it cannot act swiftly. All we have is that it hasn't done so in the past. And then if I may briefly just go to McLaren, because I submitted it is important, because it's the most recent case. It's from November last year. So it's at page 138 of that bundle, paragraph 17, where Justice Turon says, this court has repeatedly held that there must be a direct constitutional source for the power to impose a tax. The Constitution only affords a taxing power to the three elected spheres, and the power to tax cannot be delegated to the executive.
And I noted that C refers to Shuttleworth.
Yes, because that's what Shuttleworth says. But Shuttleworth responds it's not a tax. And then in paragraph 20 on the next page, the Constitution reserves the taxing power of the legislative bodies.
Sorry, paragraph?
Paragraph 20.
That's on the same page.
Oh,
Same page.
My notes are incorrect. The Constitution reserves the taxing power of the legislative bodies, and that when it permits the imposition of tax, it does so expressly and regulates how the power must be exercised. The legislative bodies can delegate the power to regulate, but not the power to tax. Full stop, end of story. No balancing act to be performed. And that's the way the case comes out. It considers, is this a regulatory charge or is it a tax? It finds it's a tax and it says therefore it's unconstitutional. Because the provincial legislature purported to delegate it to traditional leaders and the Convention. So we submit that we have very, very strong prospects of success in Part B.
Okay, so we don't need to finally decide this point, this issue, because...
Sorry.
Yes, go ahead.
No, we're not asking you to declare Section 7.4 unconstitutional, but we submit it is important that there is no answer to this. That when we get to Part B, the prospects that we will win Part B are extremely high. And that weighs when this court is performing the just and equitable analysis of whether to suspend the minister's announcement. That's obviously an important factor. And that's why I spent quite a lot of time on it. Maybe I want to deal with some of the minister's defences. Most of them have been raised by the bench, but if I may just quickly make sure I've covered all of them. The one argument the minister raises is that even if we are successful in Part B, the Constitutional Court may ultimately suspend the order of invalidity. And so if it suspends the order of invalidity, it would mean that the minister's announcement would still be valid. So the argument is the relief we seek in Part B doesn't necessarily entitle us to the relief we seek now in Part A. So we submit that there's a few problems with that. The first is you've got to distinguish between retrospective effect and suspension. We accept, and you'll see the relief that we seek in paragraph 3 of our notice of motion in Part B, says that the order must have effect from the 1st of March 2025, because we don't want to undo the 2018 VAT increase. So there was a VAT increase in 2018, we don't want to undo that. We want to stop this one coming into effect. And then it must operate from the 1st of March. In terms of suspension, we don't think there would be any basis for the court to suspend the order of invalidity, because all the reasons I've already given, it's not necessary for the minister to have that power. And so there would be no basis for suspension of the order of implementation.
Mr. Bishop, in terms of the announcement, the minister also announced that next year there's another 0.5% from March 2026. What about that?
So I think that's dealt with in the relief we seek in Part B, which we hope will be determined at least by this court before then. Yes. So paragraph 3 of our Part A relief applies to both. Sorry. So this is what we're asking this court. Paragraph 3 is the operation of the first respondent's announcement on 12 March to increase the rate of VAT by 0.5% with effect from 1 May and by a further 0.5% with effect from 1 April. So we're asking for the suspension of both because it was a single announcement. And it's been dealt with by Parliament also as a single issue. So Milady, just to conclude on this question of the prospects of success, we say it's common for this tax, it's immediate, it's irreversible, it's unconstitutional, full stop, end of story. We make a separate argument in our papers, which we'll pursue in Part B, that it's a plenary power because it's to amend the statute effectively. But we don't have to convince this court or the Part B court about that argument. I think that there's a tension between the decision in New Africa and the decision in Smith, and it's difficult to know how you square those two decisions. But it ultimately doesn't matter, because even if Parliament had delegated the power to the minister to change the VAT rate by amending a schedule or by amending a regulation, it would still be an impermissible delegation of the power to tax. We submit it's made even worse because the rate is set in the Act itself. But that's not necessary for us to win the challenge. So I then want to get to the question of the exercise of this court's just and equitable power and why it should exercise that to suspend. So we think you've got to weigh the harm of not suspending versus the harm of suspending. And you've got to do that cognizant of what the position is in Parliament. And we submit that there's three important factors. And I'm going to get to the facts on this when I get to the fiscal framework challenge, but I submit that I will show to this court that Parliament rejected an unconditional VAT hike. That the only VAT hike Parliament approved when it considered the fiscal framework was a conditional one, in the sense that it was conditional on the consideration of further alternatives and a vote in Parliament on whether to adopt those alternatives. So Parliament has not endorsed this VAT hike. The decision that Parliament did take was an unlawful decision. And if one looks at the public statements of political parties and one counts the numbers, in both the National Assembly and the NCOP, at least at present, if the vote was taken today, the VAT hike would not pass. So I'm not saying that means when it gets in 3 months politics, 3 months is a long time in politics, it may be very different then. But there's at least a very good possibility that Parliament will ultimately reject this VAT hike. And that's important consideration when this court decides whether to suspend or not. Because if Parliament had unanimously endorsed from every political party, and said, we agree, we must have a 0.5% VAT increase, and I was here asking this court to suspend it, I would have a difficult case. Because even though there might be a technical unconstitutionality, in substance, there would have been endorsement by the democratically elected representatives. But that's not the case here. Those are not the facts for this court. The facts for this court are that, at best, it's uncertain whether Parliament will endorse it, and in fact, Parliament has not endorsed it when given the opportunity to do so.
What is it that was adopted? Because the fiscal framework had that increase as part of the report. And so when the report is adopted, what is it that's being adopted?
Yeah, I don't want to avoid the question, but may I answer it when I get to the chapter on the fiscal framework?
Okay, I thought you were getting there. Okay.
But I will answer the question directly.
That's fine.
So that's the first point. The second point is, what is the harm of allowing the VAT increase to come into effect? And we submit that there are two important harms. The first is that it's an irreversible...
Doesn't it speak for itself? I mean, if you increase the VAT rate, you can't claim it back.
Yes. So it's, and I've dealt with this. The first point is irreversible, it cannot be undone. So this is unlike OTA. So OTA is an interesting example. Remember, that was about e-tolls. And one of the things that Justice Montenegro said there is that there's no irreparable harm because you'll be able to bring an unjust enrichment claim to recover your e-tolls that were unlawfully paid. And that would be possible there because you would know how much e-tolls you paid because the camera would flash at you every time you drove under the boom and you get a bill for you had all these e-tolls. And if ultimately it's declared unlawful, you can go and reclaim that money. But that's just not possible with that. Practically it's impossible. And everybody accepts it's impossible. So that's the one important thing. The second important point is that the effects of the VAT increase will be negative and will be felt most severely by those who have the least. And this is not the DA's view. This is the view that adopted by the committee. So if the court goes to page 02-183 of the record.
Just repeat that.
And my learned Mr. De Beer should be directing you.
Yes, I've got that. Thank you, Mr. De Beer. Yeah, 02183.
Yes, paragraph 4.3.1.
What is that? What?
That's
It's on the case
final report of the National the Committee that served before the National Assembly.
It's 02183.
So what the committee... So it's an annexure to the founding affidavit. It's annexure DA 13. In my papers, it's paginated page 196, but I'm trying to be technologically advanced in these papers. You have it, Maria. So what the court says is the committee is talking about the concerns. So the concerns raised include that the VAT increase would disproportionately impact middle and low income households, not just the poor, would cut into households' discretionary spending, diminishing their quality of life, and potentially exacerbating poverty and inequality. So this is recording the submissions that were made. Further down at the last paragraph, the stakeholders were further concerned that VAT is a regressive tax that disproportionately affects the working class and struggling businesses. And then the committee adopts those. So at page 02-199.
But you didn't finish the sentence there.
Sorry.
It says here, it is not backed by concrete evidence that it is less harmful to growth than other taxes. And it has not been researched enough to determine its potential impact and implication. And its alternatives have not been thoroughly interrogated.
I agree with all of that.
Okay.
I'm just worried about time. I agree with all of that. So then at 02-199, at paragraph 6.28.3, so the committee notes that increasing VAT will have a disproportionate adverse effect on lower and middle income households, exacerbate inequality and the cost of living due to its regressive nature. So the burden is although people with high incomes pay more VAT, they can afford it. People with lower incomes pay in total less VAT, but it's a bigger proportion of the income that they pay, so they feel it more. And so that's endorsed by, I don't want to take the court all of it for time reasons, but if I can just briefly give the references. By the Budget Office, where it says an increased VAT will disproportionately burden middle and low income earners. That's at page 06-79.
But are you not taking us to the question of whether or not VAT is bad or good, is good or bad?
No, maybe. I'm taking, that's a decision for Parliament to make.
Yes.
But this court has to decide whether to suspend the announcement or not.
What I mean, if you talk about the impact that it has on low-income households, and the impact that it has vis-a-vis the high-income households, isn't that going to whether or not VAT is bad or good?
No, well, that's ultimately a question Parliament will have to decide on its merits.
Yes.
What I'm saying to this court is you're confronted with not a decision by Parliament, but an announcement by the Minister.
Yes.
That announcement was made in terms of an unconstitutional law and has not been endorsed by Parliament. In those circumstances, one must consider the need for the VAT hike, which I'll get to, and also the consequences of it. This court must consider that in order to decide whether to suspend it or not. This court may suspend the VAT hike and stop it coming into effect. And Parliament may still say, we still think it's a good idea, and we're going to exercise our democratic will and bring it into.
And the court can't interfere with that.
It mustn't. It mustn't. It's not for the minister, and it's not for this court to decide that ultimate question.
Yeah, because then the court will interfere into the reign of Parliament, which it can't.
Just as the minister has. Yes. And so this court should stay out of it, but it can't stay out of deciding what happens in the interim. And it can't close its eyes to what the consequences of imposing the hike would be. But leaving open the ultimate question of how Parliament, when it actually exercises its power, weighs these competing factors. This court must not decide.
Okay, you have 15 minutes. Just as a reminder, I'm not rushing you.
We also refer to, but the point is made. So those are the problem, the harm that will be done if the announcement is not suspended. What are the harms the minister says will happen if it is suspended? So the first is he says we'll lose 13 billion, sometimes it's 13, sometimes it's 13.5 billion rand. But we submit that that's firstly it's a wrong number. 13 billion is what can be collected over the full 12 months of a 0.5% VAT hike with the estimated revenue. But what we're asking the court to do is not to say you cannot have a 0.5% increase for 12 months. We're asking the court to say you cannot have a 0.5% increase until Parliament decides. So when Parliament decides, it votes on the bill that is before it, which amends Section 7.1 to increase the VAT rate. If it adopts it, it will come into effect. And if it rejects it, the minister can hardly argue that that's harm from that point onward, because then Parliament would have said we don't want the income, and we've either found other income or we've reduced expenditure to address it. So the question is for how many months until Parliament takes a decision? We say it's likely to be in June or July, so it's 2 to 3 months from 1st of May. And how much is lost then? So it's 13 billion over 12 months, it's about 1.1 billion a month. So we're talking about 3.3 billion. What percentage of revenue is that? 0.099%. Less than 0.1% of total revenue.
Mr. Bishop, can I ask you this question? Do I understand it correctly that the minister did introduce the money bill?
Yes. Yes. I forget the name, it's got a long name. It's the Revenue and Something Matters Amendment Act. But yes, there's a bill before Parliament that to amend Section 7.1. It's attached to the founding papers. Yes.
So even if, and that's still a big if, we're with you, Parliament can, for argument's sake, tomorrow change it and introduce the VAT rate.
And that's it probably couldn't do it tomorrow. But
no, I'm just saying that.
It could fast track that process because, well, I should give an honest answer to this. It depends what happens in the second part of the case. Because if this court sets aside the fiscal framework, Parliament would first have to adopt a new fiscal framework before it can consider any of these bills. Because under the Money Bills Act, you first need the fiscal framework before you can get into DORA and Appropriations Act and Revenues Act. But once the fiscal framework is lawfully adopted, Parliament, there's no, these revenue bills can immediately be considered. There's no ordering in the Money Bills Act. It says you must do DORA first, and then you must do appropriations. But it doesn't say when you must deal with other revenue bills. So those could be dealt with immediately. The other point, so the first point is it's a very, very small loss in income we're talking about, less than 0.1% of revenue.
But that revenue goes to the very poor. I mean, the minister says it's going to certain grants. He wants to appoint more medical doctors in the hospitals. It will affect the poor, the poorest of the poor.
So there would be 0.1% more doctors for these 2 months. And the price paid for that is having less money in your pocket. That's the reality.
But isn't that the scheme that we've accepted in terms of the democracy that we're staying in? I mean, this is how we need the money in order to do all of these things.
The important word in that question, Lord, is democracy. And democracy means a decision taken by elected representatives, not by National Treasury and the Minister without public participation. Democracy means it's taken by Parliament. And so if Parliament adopts it, Parliament adopts it. But if it's not adopted democratically, that trade-off hasn't been made by democratically elected representatives, then it should not be imposed on people. The other point is about the extent of loss.
I'm just worried about the time. I'm anxious for you to get to the second issue.
I'm almost finished with the first issue.
Yes.
And I think the second issue will be much quicker. I might need another 10 minutes
Okay.
to finish that, but it's going to be much shorter than the first issue. On the Financial and Fiscal Commission also told Parliament that the amount of income they would likely get is less than you expect. If I can just give you the references, it's 02-184 and 02-199. So what the committee accepted is the probability that the proposed VAT increase might not meet the expected revenue in a constrained economic environment and weak outlook. So 13 billion is just an estimate of how much you're going to get, and the committee accepted it's actually likely to be less than that. But the second harm is the minister says, if you don't give me the 13 billion rand, which we know is really 2 to 3 billion rand, then the government will either cut planned spending or increase borrowing. The answer to that is really that there are alternatives to raise the revenue. And these are also dealt with in detail in the committee's report. Again, I don't want to take you there, but I can give you the reference. It's 02-233, where in particular, the committee notes SARS's estimated tax gap of about 800 billion, and that even with the 30% recovery rate, this could yield over 200 billion in additional revenue. And there's a range of other alternatives. The fiscal framework, and I'll get to this now, maybe, is adopted on the basis that National Treasury must come back and propose alternatives to raise the 13 billion or to cut spending. So it's not that or nothing. There are other options. So maybe for all these reasons, we submit that this court, when it exercises its just and equitable power, should suspend, because the cost of doing so is an immediate, irreversible tax increase that will affect the poorest and the middle income people the most. And the cost of doing it is minimal, less than 0.1% of revenue when there are alternatives to fill the gap. So maybe that brings me to the second part of the case, which is the attack on the fiscal framework. And we submit that there are three issues the court, three primary issues. The first is...
But, I mean, reading what transpired there, it looked like chaos, to say the least.
That's very generous. I'll get to what actually happened, but chaos is a generous description.
No, I
because
think,
it's not only chaos,
I think you
misleading.
need to take us to what the irregularities were.
Yes.
Because
Yes.
the process is quite important for us to understand what is irregular.
Yes, and I will get through exactly. But if I can say what we say the issues are is, were the final reports before the National Assembly and the National Council of Provinces consistent with Section 8.4 of the framework of the Money Bills Act? 2, was the process the committees followed lawful and consistent with Section 8.4? And finally, there's a question Parliament raises, which is, should we have challenged the decisions of the committees and not just the decisions of the houses? And just to telescope my argument, even if you accept Parliament's version that the committee's reports just had a non-binding recommendation, it's still inconsistent with Section 8.4. But if you look at what actually happened, it was not a non-binding recommendation. 1, it was a strict condition, and 2, no vote was ever taken on the fiscal framework. And if one looks at what happens in the committees, that's clear, and it's actually common cause. So I want to start very briefly with the purpose of the fiscal framework. And I'm just going to have a long argument on this, but I'm going to summarize. But the purpose is to set the revenue and expenditure estimates for the budget process. And those then bind Parliament in proposing amendments to the various money bills that follow. The Division of Revenue Act, the Appropriations Act, and the Revenue Bills. Parliament cannot propose amendments to those acts that are inconsistent with the fiscal framework. So once it accepts that we're going to have 2.2 trillion rand of revenue and 2.4 trillion rand of expenditure in the fiscal framework, those are the numbers that have to come out in DORA. So when the Division of Revenue Act, Parliament divides money between the provinces, national and local government, it must divide the 2.4 trillion that it agreed to when it adopted the fiscal framework. And when it considers the revenue bills, it must raise the 2.2 trillion that it agreed to when it adopted the fiscal framework. It cannot spend more and it cannot raise less.
So what happened if Parliament amended the fiscal framework to put the alternatives and removed the VAT increase? What would have happened there?
Then, because it's not the minister that sets the fiscal framework, it's Parliament.
Yes.
So the minister would have proposed one. Parliament could have amended it. Could have amended it in different ways. It could have said, we're going to take out the 13 billion and we're going to cut 13 billion from expenditure. And then it would have a fiscal framework that complied with the requirements, and that would have then bound them going forward. They have 13 billion rand less to spend. Or it could have said, we're going to raise the 13 billion not by raising the VAT rate, but by borrowing 13 billion, or by taking it from the reserves, or by raising income tax or some other money. The various alternatives that are in the committee's report. But what it would have to do is balance revenue, borrowing, and expenditure. And whatever it decided when it adopted the fiscal framework would govern what it does when it adopts legislation going forward. But that's why the fiscal framework is so important and why it must be clear and it must be final. You can't have a fiscal framework that is subject to amendment down the road, because then you don't know what your limits are when you pass the Division of Revenue Act, the Appropriations Act, and the other acts, because they're still up in the air. And that's why Section 8.4 says that the report must include a clear statement accepting or amending the fiscal framework.
Can you just take us through the process of what actually happened?
Yes, let me, Melanie, if I may, I don't want to keep avoiding your question, but I want to deal with it in this way.
Because I think that's quite important, because we have to know what was wrong with the process.
Can I answer first on Parliament's version? Parliament says it doesn't really matter what happened in committee. Look at the report that ultimately served, the final reports that served before the National Assembly and the National Council of Provinces. And it says all those did is they had a non-binding recommendation, and therefore, and those were adopted by the houses, and that's good enough. So one has to look at what is that non-binding recommendation, and it appears at page 02199 for the National Assembly. You don't have to go to this other one, but the reference for the NCOP is 02235. It's identical. And it's paragraph 6.29.
6.29
and 6.30.
Yes.
The committee recommends that the Minister of Finance facilitate the receipt of substitute revenue proposals from the committee, together with corresponding expenditure savings, that will form the basis of an alternative revenue proposal instead of the proposed 0.5 percentage point increase in VAT, in respect of which the committee has expressed serious concerns. Furthermore, the committee recommends that the alternative revenue proposals and expenditure savings to balance the 28 billion rand shortfall, which must effectively suspend the proposed increases, be finalized and submitted by the committee to process within 30 days, and this is very important, for consideration and adoption of this report by the House. So what it's saying is we have a recommendation that National Treasury must consider our proposals, come back with its own alternative revenue proposals within 30 days for consideration and adoption of this report by the House.
But then what was approved? What was approved?
So you've got to read the report as a whole. The report does contain the statement, having considered the 2025 fiscal framework, blah, 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 the committee accepts the 2025
Where are you reading from now?
So this is at page 02204. So it's right at the end of the report.
Okay.
So this comes first, the recommendation, and then right at the end of the report, this is tacked on.
But that's belatedly tacked on. I mean,
Yes.
the minutes suggest that something was approved in the committee.
Yes, maybe I'm going to get to that. I'm saying even if one ignores what happened in committee, even if what happened in committee was squeaky clean, what served before Parliament, before the Houses and plenary, was inconsistent with Section 8. Because although it contains a statement of acceptance, it's subject to a recommendation. It's subject to a recommendation that envisages a change to the fiscal framework. Because if National Treasury comes back with alternative revenue proposals, and those are considered and adopted by the House, that means that there won't be a VAT increase, and the fiscal framework will be different.
But reading between the lines, isn't that what ultimately the committees wanted to achieve?
Yes, but they weren't allowed to do it by the Money Bills Act. Because the Money Bills Act doesn't allow you to set the fiscal framework and say, but we might still change it later. You've got to set it and stick by it. Because it's so important in regulating what happens thereafter in the budget process.
But it requires acceptance or amendment.
Yes.
So why did the committee then not stand firm on giving neither?
Yes. So if I can let me get to what actually happened in the committee, because I think that's important. So we say that there are 5 important facts. So the first is that the draft reports did not include a statement accepting the fiscal framework. That's common cause. Parliament says the reason is that the committees first had to decide whether to accept it, which is fine if Parliament either amended the report before the vote in committee or took a vote on the fiscal framework in committee. But it is also common cause that the committee did not vote on the fiscal framework.
But what did they do then?
So what they did is that
Is
there
there a
were...
transcript of the meeting?
There isn't what we provided as a YouTube video.
We couldn't
And-
find it. Can you maybe send us a link? Someone send us a link,
Yes. I'm
because
sorry, the other parties have managed
we
to do
couldn't
that.
find it. We tried to locate the YouTube link that you sent us, but we couldn't.
Could you resend it?
Yes. What I can also try to do is provide a transcript to the court.
Okay.
We'll probably take a
How
day or
long
two.
are you still going to be? Can we give you 5 more minutes? But when we come back from tea, we're going to adjourn and then come back. Unless you want to close this point quickly.
Not maybe at the tea now. I'll need 5 to 10 minutes.
10 minutes is a long time. You have to ask your colleagues to borrow some of their time.
In my
Okay.
defense, I'm the only person who has to address both.
Okay,
parts of the
that's
case.
fine.
So it has taken a little bit more time.
That's fine. We'll give you 10 more minutes when we come back, and we'll have to readjust the time perhaps at lunchtime. All right, the court adjourns. Okay, thank you, Mr. Bishop. You've got your 10 minutes.
Yes, that's just before the agenda, I finally got to what happened in the committee.
Yes.
And I said there were 5 important facts. So the first one is that the draft reports did not include a statement about the fiscal framework. That's common cause. The second is that the committee did not vote on the fiscal framework separately. They only voted on the report. That's also common cause. The third important fact is that
Okay, just on that one, the committee did not vote on the fiscal framework separately. Did the report not contain the fiscal framework?
It contained a description of the fiscal framework,
Yes.
but it didn't contain the statement you find in the final report that the committee accepts the fiscal
So
framework.
it is the statement that you say was not voted on.
So both. So one, the statement was not in the draft report. And the report, so when they voted on the report, they voted on something that did not include a statement accepting the fiscal framework. It included a description of the fiscal framework.
Now, what did they vote on then?
It's a very good question, Lord. So what happened is various amendments,
Yes.
motions are proposed over the 7 hours of the meeting. And those are then voted on. And they voted up, or they voted down, but they're all amendments to the report. So various amendments are made to the report. None of these are reduced to writing into a new report that is then placed before the committee so everyone can read it and see what it says.
So when were these amendments made? Were they at the meeting or were they after the meeting via email and correspondence?
So they were done verbally during the meeting.
Yes.
So that somebody will propose. So let's take Mr. Beasley of Action SA, because this is the most important one.
Yes.
So if I can take the court to page 05-19. So this is from Parliament's answering affidavit. And it's recording the amendment that Action SA proposed, paragraph 40.
So just give us a moment. 05?
-19, paragraph 40 of Parliament's answering affidavit.
Okay.
Yes, I'm.
Do you have it, Malaysia? So it says Action SA proposed the following amendments. The fiscal framework tabled by the Minister of Finance is supported, and I emphasize, subject to the strict condition that National Treasury facilitates. And what goes on is what I read to you previously that found its way into the final report. But the important difference is it's not just a recommendation, it's supported subject to the strict condition that. And that amendment is then proposed by a member of the ANC, accepted by the ANC, seconded by another member of the ANC, and adopted by a majority of the committee as an amendment to the report. And there were various other amendments to the report that were adopted. Amendments proposed by my client, by Mr. Mukatogi's client, were not accepted. They were voted down. But this is all happening verbally. Someone reads out an amendment, the vote is taken, it's either accepted or not, and the committee moves on.
So the secretary of the committee produced a draft, and this draft is debated in the committee, and amendments are made in the committee, and some are adopted by the majority and some are not.
Yes. And then a vote is taken, do we accept the report? And then people say, but what are we voting on? So we record this in our replying affidavit. It's page, you don't have to go there, I just want to give you the reference, 06/12 from paragraph 27, where we quote various members of the DA, MKP, the EFF, who are all expressing confusion about what are we voting on. Parliament's position is that what was voted on is the report with all the amendments that had been verbally accepted during the meeting, and implicit in that was an acceptance of the fiscal framework.
Did someone clarify, as questions were asked, what are we voting on? Did someone say, this is what we're voting for? The chairperson saying, this is what we're voting for?
So if one listens to the meeting, it's particularly sort of the last hour of the meeting where most of this happens. Sometimes yes, sometimes no. But ultimately, even after these clarifications, members are raising a concern that I still don't understand what we're voting on. Are we accepting the fiscal framework or not? Because what Action SA says is it says, we are against the VAT increase. Mr. Beasley says that expressly. He says, I want to be clear, Action SA is against the VAT increase. And then he says the amendment that is adopted is, we support is, so I want to get the wording correct, says, the fiscal framework table is supported subject to the strict condition that. And so there's two important points in there. The one is that there's just never an actual vote on the fiscal framework as it stands. That's never put to the vote, and it's never in the report. The only report that is adopted is support with a strict condition.
But doesn't the fiscal framework form part of that?
But remember, Section 8.4 requires a clear statement accepting or amending. And what's here is acceptance subject to a strict condition. That's what the committee votes on.
But that's not an amendment in the true sense of the word.
Exactly, and it's not an acceptance in the true sense of the word. So it's neither an acceptance nor an amendment. So there's non-compliance with Section 8.4. That's the problem. The other problem, Lord, is this is very different from what's in the final report, which I took you to just before the break. There, the strict condition is morphed into a recommendation. But there's a world of difference between a strict condition and a recommendation. Because strict condition means if National Treasury does not come back with alternative revenue proposals, our support lapses. I'm not sure it's a resolutive or a suspensive condition, but either way, the support will lapse because the strict condition has not been fulfilled.
Can I just understand, at the meeting itself, the proposal by Action SA was adopted, that strict condition.
Yes.
But the report, in fact, did not refer to the strict condition, but the recommendation.
Correct.
Okay.
Correct. And so,
And then also inserted was the acceptance.
yes, which was not in the draft report prepared before the meeting and was never put to the committee during the meeting.
To which the GA, Mr. Brits, then responds and says that it doesn't reflect what was discussed, and then a further amended version is sent, and then
Yes.
he responds again later that evening.
Yes.
It's also not what was discussed.
Yes. And so, my argument is, even if you, my first argument was, even if you accept that just a recommendation, and that is in fact what the committee adopted, that's not consistent with Section 84. But it's not what the committee said. The committee said strict condition. It's watered down in the report. But a strict condition can never be, as your Lordship pointed out, either acceptance or amendment. It's conditional acceptance. And it is premised on the idea that the fiscal framework may change, because Treasury may come back with an alternative revenue proposal, which will be voted on in the House within 30 days, which will remove the VAT increase.
But can that still happen? We're not past the 30 days yet.
Notionally, it can still happen, but the point for us is that when Parliament voted on the fiscal framework, the Houses on the 2nd or the 3rd of April, that's what we're challenging as unlawful. And we're saying that was unlawful because they needed a compliant committee report before them that accepted or amended the fiscal framework, and they did not have that before them.
So what did Parliament vote on?
When the plenary, when they voted in plenary, they voted on these reports that had this, was itself contradictory because it says we accept with recommendation, and did not reflect what happened in the meeting. Because what happened in the meeting was neither a recommendation, it was a strict condition, and it was not an acceptance because that was never.
So they voted on reports that were prepared by the Secretary to the committees.
Yes. So
the Secretary took a view that there'd been acceptance.
I think Parliament's argument is that they say it's implicit. Because we adopted the report subject to all the amendments we did, implicitly we accepted the fiscal framework. Our point is you couldn't have accepted the fiscal framework and accept Action SA's amendment. Those are mutually inconsistent votes. And so having a clear vote accepting Action SA's amendment means you could not have voted to accept the fiscal framework. Because you can't do both.
So then who came up with this acceptance?
I assume the Secretary drafted it, but it would have been approved by the committee. I don't know if there's an answer in the papers to that. I can look it up and give it to you in reply, but I'm not sure exactly who. But ultimately, it would be the chairperson who would have to table the report before the House. He would receive comments from the parties who would object to it, and various parties did object to it. He said, we don't think that was ever voted on. There's all the letters that are attached to the my client from EFF. We say we don't agree that that reflects what happened in the meeting. But ultimately, the chairperson puts it in. So maybe that's why the adoption of the fiscal framework is unlawful. Whether you take Parliament's version or what they pretend happened in the committee, or whether you look at the facts of what actually happened in the committee, either way, it's unlawful. So that brings me, I've just got three quick points. The first is there's a procedural or technical argument raised by Parliament to say we should have challenged the decisions of the committees and not just the decisions of the National Assembly and the National Council of Provinces. And our answer to that is threefold. The first is that it's irrelevant. Our attack is on the National Assembly and the National Council of Provinces. And we say those decisions are unlawful because one of the jurisdictional facts for them to take that decision was a report from the committee that was compliant with Section 84. So imagine that Parliament took a decision without any report from the committee. That decision would be unlawful, and we would just challenge that decision. Imagine they had a committee report before them that said expressly, we have not yet taken a decision on the fiscal framework. And Parliament adopts the fiscal framework anyway. That would be unlawful because it would have been taken without a report compliant with Section 84.
But did they not have before them a report in terms of Section 84? We now know that there had been this problematic process, but Parliament had before them a report which on the face of it complied with section 8.4.
So that's why I said the first level of our case is that even if you accept that this report was a reflection of the process out of the committee, it's still not a section 8.4 report because it's subject to, it's because of the recommendation. And the recommendation anticipates the possibility of changing the fiscal framework. So even if one ignores what happened in the committee and just looks at the final report, we come home. But we say there's an additional problem that the final report before the Houses does not reflect what the committee in fact did. But I can win the case just on the first argument.
I just need your answer on the point you mentioned that they're saying that you should have attacked the report itself.
Yeah.
You're not asking for the setting aside of the report. They say, well, Oldecral says that it's a decision on its own which must be attacked on its own. Yes. Until such that you do so, then it stands.
Yes. So we submit that's wrong as a matter of law, and we set out the case law in paragraphs 127 to 128 of our case, which deals with multi-stage decision making. So where often it happens in a tender context or a regulatory making context, where one body makes a recommendation or proposal to another, and the other body has to accept or reject the proposal or take the final decision. And the courts are very clear that in that context, you only challenge the final decision. You don't have to challenge the previous ones because those have no legal effect. They're just recommending to the final decision maker. And that's the case here. The report of the committee has no consequence other than to trigger the power of the Houses to have a vote. That's the only consequence it has. Because it's the adoption of by the Houses of the fiscal framework that then triggers section 8.9 and section 9.1. So 8.9 is the one that says what the House has adopted. You cannot propose amendments that are different. And section 9.1 says once the House, the resolution of the National Assembly, triggers the obligation to then consider order. And so the committee has no legal consequence under the Moneyballs Act. The committee report. If we come to court challenging the committee report before the House had made a decision, we would have been told you're premature. Why are you here? Wait for the Houses to take a decision. And correctly so.
Okay, can you wrap up now?
Yes, so two very brief points. Just the difference between our approach and the EFF's approach on this issue. We ask for final relief. We want the decisions of Parliament set aside. The consequence will be that the budget, or at least the consideration of the fiscal framework, for this court to act in Part B. That's why we say final relief is preferable, because it deals with the problem, Parliament knows what to do, start again.
It looks like the Commissioner, although he's not part of Part A, has a similar view on this.
Yes.
With regard to the relief sought in Part A.
Yes.
That it should be final relief and not interim relief.
With regard to the fiscal framework?
Yeah, fiscal framework.
Yes. Yes. And when we submit that is the more appropriate course. It seems more drastic, but in this context it's actually more respectful of Parliament, because it lets them get on with it, rather than holding them hostage until this court acts. But it's open to this court to grant either. Finally, on costs, Milady, we submit Biowatch clearly applies to this case. So if we are successful against Parliament, we seek our costs. If we are successful against the Minister, we seek our costs, but I'm aware that in interim applications sometimes costs stand over the Part B, so we would have no objection costs as against the Minister, because that's interim relief, are costs in Part B. Both the Minister and Parliament ask for costs against us if we're unsuccessful, because they say the Democratic Alliance is a political party here for political reasons, and therefore Biowatch doesn't apply. That's wrong. The case that says it's wrong is Democratic Alliance versus President of South Africa. The citation is 2014 4 SA 402 WCC. It's a decision of this court, paragraph 108, where Justice Rogers, exactly the same argument made. This was a challenge to e-tolling legislation. Exactly the same argument that the DA is politically motivated and therefore can't be protected by Firewatch. And what the court says is, one must have regard to the character of the litigation itself. The present case raises genuine and substantive constitutional issues regarding the approach to tagging. The application is by no means frivolous or vexatious or manifestly inappropriate, and therefore Firewatch applies. Firewatch says expressly in, I think it's paragraph 20, paragraph 16, that the motive is irrelevant. What matters is the character of the litigation. And so the fact that my client is a political party is irrelevant to applying Firewatch. Those are submissions.
Thank you, Mr. Bishop. Anything from you? Anything?
No, I've got no.
Okay, Mr. Ngaitabi.
Thank you, my lady. Can I start by acknowledging the fact that it's my first appearance for your leadership in the new position.
Indeed.
Thank you, and just a word of congratulations.
Thank you.
I want to make 3 submissions in support of the relief sought by the EFF. We don't have the same problem that the DA has, because we have challenged both the decisions of the Standing Committee and the resolutions of the National Assembly. So the difficulty that Parliament puts up, not that it is valid, but it doesn't apply to us. So the submissions we will make in support of the interim relief to suspend the operation of the committee decisions as well as the adoption by the National Assembly are the following. The first one is a narrow one relating to the VAT rate increase. We will submit that in addition to what Mr. Bishop has said, the VAT rate increase is substantively unconstitutional. I will deal with the implications of Section 9 of the Constitution. The second part of that argument is, I will submit that the process through which the VAT increase was adopted is itself irrational and unconstitutional. In fact, it has elements of deception, because what they did, the minister and those who sponsored the increase created the impression that it was subject to change. When you now read their affidavits, they say that they've always known that it was never subject to change from the 12th of March. So if you are a public representative and you go to Parliament and you tell your colleagues, don't worry, vote with me, this may change, you are deceiving them. And that is an improper use of public power. The third argument would be then to challenge the fiscal framework under Section 8.4 of the Money Bills Act. We have prepared a chronology, which I will refer to when I deal with the third part of the argument. Maybe I should end this up.
Can I just ask you if my constitution that lies there? And my pencil case is not there.
So let me then deal with the first argument why we submit that the VAT rate increase is substantively unconstitutional. The first is just to set the constitutional scheme for budgeting decisions, which we have attempted to set out in our heads of argument. From page 1311, paragraph 25 of the head of argument, that's where it starts. The first point we make is that the budgeting power is constrained by the Constitution. All budgeting decisions are constrained by the Constitution. And the constitutional constraint is not only the principle of legality. Another constraint is the Bill of Rights itself. And we say the fact that the Bill of Rights has a constraining effect on budgeting decisions has two implications for us. The first is that when budgeting, there is a positive duty to achieve equality. And that is spelled out at paragraph 25.1 from the Battlestar decision. The second implication is that there is a negative duty not to take regressive measures. Sometimes they're called retrogressive, but the report calls them regressive. But those obligations apply when you are taking decisions such as budgeting. We say that there are a number of judgments that have had budgetary consequences that have been taken by our courts. And the courts have never shied away from making a ruling where the Bill of Rights is implicated simply because the word budget is mentioned. We referred to those cases from paragraph 26.1, Rail Commuters Action Group versus Transnet, 26.2, the Blue Moonlight decision. In fact, Blue Moonlight was even more intrusive because the state argued in that case that it had not budgeted for something. It was not even budgeting, but doing it inappropriately. And the Constitutional Court said it is not good enough for the state to state that it has not budgeted for something, if it should have indeed planned and budgeted for it in the fulfillment of its obligations. And so we say here in this case where the committee itself, because I will go through the report of the committee and I'll isolate the item, took the view that the VAT increase was a regressive measure. It also took the view that the VAT increase would exacerbate inequality and adversely impact the poor. And both Parliament and the Minister simply do not engage with those arguments. In fact, Parliament says it's an irrelevant factor. But it's pleaded expressly in the founding affidavit of the EFF as a material
Can I just ask Mr. Ngaitobi, doesn't this take us to the policy-making arena and
Yes.
the decisions that have to be made by other arms of the state and not the court?
Well, we submit that even if it does, even if you are crafting policy, which is the core function of the executive, it must still comply with the Bill of Rights. And you still have the obligations that are both negative and positive. And so it's not outside of judicial scrutiny. So we say that what the minister also simply does not engage with the arguments. What he does is to traverse trite territory about polycentricity, arguments that have been long rejected because it has long been accepted that the mere fact that a decision is polycentric does not mean that it is immune from judicial review. So we say that our courts have not viewed budgeting as a constitutional holy cow. And we set out all of the judgments that have budgetary implications that have been made from footnotes 20, 21, 22, and 23. So then, what are the facts in this case? What do the facts show? Firstly, the EFF alleged at page 07/24 from paragraph 110 of the founding affidavit expressly that the rights that will be impacted are the rights to substantive equality, particularly of the poor, that stand to be hit the hardest by the unlawful VAT hike. Section 9. Section 10, paragraph 1102. Section 25, paragraph 1103. Section 27, paragraph 110 and 1105. Section 29. But for my purposes, it's enough to stick to one right, which is the equality right. What the committee itself found you will see at page 02/128, at paragraph 6.23.3, and this is the conclusion of the committee. I think Mr. Bishop said something about this being a recording of the submissions. No, it's actually a conclusion of the committee. That's how they assessed the evidence in front of them. They said, and you see this at 628, where they say the committee notes that the proposal to increase VAT by 0.5 percentage points in 2025 and 2026, which will take the VAT rate to 16%. The committee further notes the following, so that's their finding. 6.283, that increasing VAT would have a disproportionate effect, adverse effect on the lower and middle income households, exacerbate inequality and the cost of living due to its regressive nature. And later on at 6.286, they say the following, that most stakeholders, however, have strongly opposed the VAT increase, particularly in the context of the ongoing cost of living crisis. That's actually a gross understatement. What had happened is that there were 48 submissions. Only 2 supported the VAT increase. It was PEP and PricewaterhouseCoopers. Every other submission rejected it. So you have a scenario in which the public participation process and the VAT increase is opposed by more than 98%. In fact, it then becomes a farce. The whole participation process becomes totally farcical. So when they say most stakeholders, what should have been here is that about 98% said no. 6.287, they say the following. The committee therefore acknowledges that while the VAT increase contributes significantly to the revenue framework, it raises serious equity concerns and must be carefully monitored for its impact on low-income households. There is a need for ongoing assessment of mitigation measures and transparency regarding the revenue raised and how it supports inclusive expenditure priorities. I will say that there was no such inclusion. They noted the problem, that there are equity concerns, that there should be mitigation measures, but there were no such mitigation measures.
Doesn't this issue not go to the question of ambiguity or the fact that the conclusion reached or the conclusion reflected on the report is not supported by the narration of the committee and what the committee actually debates and finds in its report?
No, look, my lady, if I may say, this is an excellent point. It addresses I had seen it as an equality point, but it's also a rationality point. And then the solution, if one recalls, that was proposed by the minister was to zero rate certain items. But that is expressly rejected by the committee at 6.30, where the committee says, the committee notes the National Treasury's position on zero rating is a blunt instrument, as poor households still pay VAT on non-zero rated products and services. The committee recommends that the National Treasury should consider the recommendations made by the stakeholders on the list of zero rated items, which include an establishment of an independent expert panel to evaluate. So they did not find that the zero rating is sufficient protection for the inequality problems that the increase would exacerbate. And then at 6.31, as the committee notes the decision to not adjust PIT brackets for inflation, generating 19.5 billion in additional revenue. And then look at what happens next. The committee is concerned about the impact on lower and middle income households and recommends that National Treasury assess the equity implications of the fiscal rate and explore alternative progressive tax measures. And at 6.33 on the same page, the committee recommends that National Treasury and SABC should reconsider these proposals and engage further with the stakeholders to assess the viability of selected alternatives, especially where proposals are supported by credible empirical evidence. So I've taken 6 parts of the report where the committee itself acknowledges expressly that the 0.5% will exacerbate inequality. And this is in a country which already on the Gini coefficient is the most unequal in the world. Now, none of these were actually considered and these concerns when the decision was made. The mitigation measures that were mentioned were simply not brought into operation. So it's therefore clear on the facts that the 0.5% percentage increase is a regressive measure. It exacerbates inequality. It is therefore in breach of Section 9 of the Constitution. You would therefore expect to find a substantive justification in the answering papers. The problem is that the answering affidavit of Parliament avoids the topic altogether. In fact, it says this is not the issue. It's not clear how they could have come to that conclusion in the light of the EFF intervention that squarely raises the topic. And then you think, well, maybe the minister will give a substantive justification based on the equality concerns. But you also find that the minister does not, in fact, justify the 0.5% other than by saying we need additional revenue to cover a number of other government spending requirements.
Does it not say to ameliorate that we're going to increase the number of goods that are zero rated?
Yes, but that's already been rejected by the committee itself, because it said the zero rating is a blunt instrument because the poor still have to pay for the other goods that are not zero rated. In any event, there is no zero rating right now because it is yet to happen through this independent panel that is yet to zero rating. So at the time the decision is made, there is no evidence of what is the impact of zero rating on the poor.
So by the 1st of May, there will be no zero rating to speak of.
There will be no change in zero rating. But the poor must pay the percentage increase.
Well, in fact, there's no panel yet.
There's no panel at all. So that zero rating, as Parliament said, is a blunt instrument. It doesn't take us anywhere. So we have a scenario in which there is a clear violation of constitutional rights. The two organs of state that are responsible for budgeting have forgotten their constitutional obligations to the poor. And we don't have to succeed on a final basis. This is a case that depends on the prima facie right. So we say that is sufficient. And here it is not as if there are no alternatives. And again, they don't have to take the EFF alternative. The EFF says must tax the rich. But you can ignore that and say that's political rhetoric. But what you cannot ignore is the Commissioner for SABC, who himself says there are alternatives. And those you will find at 02/121 under paragraph 5.2. And the last paragraph there, where SARS is making a presentation, and they say the presentation estimated South Africa's tax gap to be between
Sorry, where are you reading from?
I am at 02/121.
Yes, I'm there, but
Yes, at the last paragraph, under paragraph 5.2.
5.2.
Yes.
Okay, let me just get there.
Yes.
Yes, you may proceed.
So this is what SARS says as clear alternatives. The presentation estimated South Africa's tax gap to be between 700 and 800 billion annually, with only 58% of the theoretical tax liability being collected. So that's 42% uncollected tax. And on time. SARS identified key under-resourced areas, including illicit trade, syndicated tax crimes, aggressive tax planning by large businesses, international tax compliance, high net worth individuals, cost of entry, and debt recovery. So that's where they say the money will come from. SARS outlined immediate and medium-term plans to enhance compliance and revenue recovery. These include expanding the debt default recovery program, which is in a pilot phase, resolved over 600,000 cases and collected 25.2 billion in cash over 15 months. At a cost of 300 million. SARS plans to increase full-time equivalents from 858 to 2,500, with the goal of collecting 20 to 50 billion annually. Additional strategic investments of 2 billion per year are required to support this effort. And then that goes on to the last paragraph in that page. So the point is that Parliament itself and the Minister himself were told by the Commissioner of SARS that there are alternatives to the VAT increase. We're not told by my clients or the DA or anyone. We're told by their own commissioner.
I'm just going back to the policy choice question and the courts of how far can the court interfere in that arena, where SARS says and the minister says, well, these are the policy choices that we've made. We've looked at alternatives, and we find that it will leave the poor worse off than this other one. Can the court say that?
Yes, if the Bill of Rights is implicated. But the problem is that the Bill of Rights is actually a trump. So you have to make those. The law is not that the government can simply assert that we've made this policy choice. The law requires the government to account by reference to the standard in the Constitution about why they have made policy choices and why they have rejected certain alternatives which were made and have made available to them. So there is no constitutional blank check simply because you use the phrase budgeting. And so that's just a narrow case. In circumstances where, one, it's clear that there will be an exacerbation of inequality, and two, it's clear that Parliament itself says there will be inequality, and it's clear that there are available alternatives. It's arbitrary then in those circumstances to suck your thumb and say, I'm sorry, I want to increase. So what we are asking the court to do is to be more exacting in the evaluation of the conduct by the minister. So we submit, therefore, that there is a strong substantive argument in favor of suspending the decision pending a review in Part B. And we say when we actually evaluate the answering affidavit, there are no direct answers. But when you look at the answering affidavit of the minister, it starts at paragraph 68 in the EFF answer, just never answers anything that comes before paragraph 68. Then I must move on to the second problem that we have, specifically just on VAT. The second problem is that what they seem to have done, the minister and those who promoted this vote in Parliament, is that they have simply said, look, since the Action SA fell for it. But it doesn't matter, Action SA were acting as members of Parliament, not as a separate political party. Also say, look, don't worry about this. We can put in a condition that we will change this in due course. So vote for it. Now, there is a fundamental problem with adopting that approach. It may be politically convenient, but it's deceptive. And public power should not be used deceptively. Public power, the first and the primary duty is that you must be honest.
Now, the minister's decision has not been directly attacked by the EFF.
No, we say that we don't have to, because our challenge is, because you remember that the deception did not come in the introduction on the 12th of March. It came on the 1st of April. So we say you've got to look at his conduct in totality. His conduct in totality reveals deception.
Yes, no, I understand that, but what I'm saying, the relief sought, there's no, if I recall, there's no order sought against the minister's decision to say you impugn this decision, this conduct, and therefore the decision must be set aside or must be reviewed or we must do something about it. So there is no direct challenge against the minister. That's what the challenge is against the reports of Parliament.
Your leadership is correct. What we submit there is this, that the minister's decision under Section 7.4 is part and parcel of the budget. Unlike the DA, we don't accept that if the fiscal framework is set aside, there is a self-standing decision of the minister that survives the setting aside of the fiscal framework. Our reading of Section 7.4 is that the two are inextricably connected, especially when you look at the text of the section, which says if an increase is contemplated as part and parcel of the budget under Section 27 of the PFMA, then the following must take place. We see that as meaning that because the increase is part and parcel of that budgeting in the fiscal framework, once that budgeting in the fiscal framework falls, so does the minister's decision.
So once the resolutions from Parliament are set aside,
Yes.
then then you're saying Section 7.4 cannot come into operation, or rather the announcement cannot become effective on the 1st of May?
Not independently. Because this is what the minister again has said, it really becomes a problem when politicians act like this. Throughout, the minister did not on the 1st of February say that I'm trying to increase VAT. He said on the 12th of March, I'm trying to introduce a budget that includes a VAT increase. That's what he said. Throughout, he always accepted that the two go hand in hand. The first time there was a theory of separation is when the answering affidavit was filed. So even his own conduct showed that he understood the two to go together. So that's why it's not appropriate right now to try and separate the two. The two decisions are one and the same.
So the VAT increase is tethered to the annual budget.
Precisely.
And tethered to the annual budget is a resolution approving the fiscal framework.
Precisely, yes. And throughout the debate, the main issue that these parliamentarians debated was the VAT increase. When they were trying to adopt the budget and trying to pass the fiscal framework, they were debating the VAT increase.
But where's the deception?
No, that is not the deception.
Oh.
The deception is the idea that this is subject to change. When they knew that they had no intention of changing, that was deceptive.
Is that not politics?
Yes, but there is no problem with the politics per se, but we are concerned with here is the conduct of the members of Parliament in Parliament and the message they're sending to us as the voters. Now,
Mr. Nkatobi, isn't it perhaps just a misunderstanding of the whole legal framework, of the fiscal framework? How it impacts and how it fits into one another? Wasn't there perhaps a misunderstanding rather than a deception?
there could be there could be a misunderstanding, I accept that. But where the minister today, if one looks at his answer and says that I never thought this was going to change from the day I announced it on the 12th of March.
So he knew beforehand.
He knew beforehand. So it can only be deception when in Parliament the impression was created that these recommendations can be put and these recommendations can be altered. In fact, my Lord, I'm glad you raised that question because it's not me saying this. It's actually Mr. Athol Trollick. If you go to page 07/18.
Just give me a second. Yes, I'm there.
Yes. So 07/18, paragraph 47 says Athol Trollick, who is an MP and Action SA's national leader, is on record making this exact point in a media briefing he hosted on 2 April 2025, following the National Assembly and NCOP's adoption of the impeachment report. In that briefing, he made the following statement. 47.1, as per its negotiations with the ANC, Action SA's support for the fiscal framework is conditional on the finance minister scrapping the VAT interest recorded in the annual budget and fiscal framework. 2, having expressed his irritation with his perception that the ANC is reneging from its appointment and misrepresenting the facts leading to the adoption of the impeachment report, Trollick asserted that the ANC must implement Action SA's recommendations, which were the preconditions as stated. 3, pulling out his phone and reading his negotiation exchanges with the finance minister, he stated that the latter said to him, I imagine you will be able to come up with proposals to replace the revenue proposals, to which Action SA made its conditional support proposals. It was at this point that the poison tree blossomed and gave rise to the impeachment report fruit. It is that sequence of events that gave rise to this amendment proposal, as agreed with the finance minister and the ANC. Then it goes further. 4, Trollick went on record that following that precondition and concession, Action SA then approached and convinced Bosa and Rise and Zanzibar to vote in favor of the impeachment report adoption. He repeated the condition in another interview, to which I will refer to in a moment. So, it is him who said the minister has misrepresented the truth. So I say that the minister is guilty of deception. So once you have a budgeting process that is so colored by deception, it is fundamentally in breach of the duties imposed on members of Parliament, especially our executive, National Executive Committee. So you cannot endorse a budgeting process where the deception is so clear. And in fact, you know, my lady and my lord, I've been reading from paragraph 47. If you actually go to the minister's answering affidavit, so fine. The answering affidavit starts at 035. There's something that will shock you, because the answer to the EFF is at 0351.
Zero.
0351.
Yes, I'm
That's
there.
where the answer to the EFF starts, the seriatim. And you see where it starts at paragraph 85. And at paragraph 47, which is where the accusations of misrepresentations are made, is just not answered.
Sorry, you on zeros?
0351, and I'm comparing that with 0719.
Okay, yes.
So if you go to 0351, where they start the seriatim response to the EFF at paragraph 101, they start at paragraph 85. So compare that with paragraph 47, where the accusation is made by Trollick that the minister is guilty of misrepresentation. That is a very, very serious accusation. You would have expected that it would be met frontally. It's just not an answer.
So what must we make of that now?
Well, it still comes back to whether or not a report that is undermined by deception and misrepresentation can pass the rationality standard. Because remember, the EFF challenges this report on substantive unconstitutionality and irrationality. One of the grounds for irrationality has been highlighted by the leadership presiding, which is there's a mismatch between the content and the outcome. But another one is that this is a report that is a product of deception. It's not honest what happened here.
So at the time the minister engaged Action SA, he knew that the VAT rate which he announced on the 12th of March cannot be changed.
That's what he says now in the answer affidavit. He says, from the onset, I made my decision on the 12th, and that was it. So then that calls into question then what on earth was he doing with Trollick lying to him? So you will see this right at the beginning of the minister's answer affidavit. I'll find it now. Yes. So it starts at 03.12, paragraph 15, where he says, I exercised this statutory power, talking about section 7.4, on 12 March 2025. Then next please. There is a specific paragraph that says that it's where they deal with the separation, where they say it's clear that these two are separable, and once announced, it cannot be changed. I will find it. If I don't find it before I finish my argument, I'll tell the court at a later stage. Yes. It's 0324, where he's talking about the implementation of the VAT decision. So paragraph 48, and then paragraph 50, where he said, that said, the decision as to whether to give permanent effect to the VAT rate adjustment now lies with Parliament. In due course, Parliament will consider and
Sorry, let me
debate
just get there.
0324. So the first one is the very top of 0324, paragraph 47.
Let me just get there.
In fact, 0323, paragraph 46, that's where it starts. Yes, I've now found it.
Yes.
Since its announcement, the decision has been widely communicated across the country, and businesses and consumers alike have relied on it in planning for the financial year ahead. Paragraph 47, the VAT rate is therefore set to increase to 15.5% on 1 May 2025. And paragraph 50, at the same page, that said the decision as to whether to give permanent effect to the VAT rate adjustment now lies with Parliament. In due course, Parliament will consider and debate proposed legislation, and to the extent it sees fit, pass or amend it in accordance with the procedures set out in the Manifest Act. So it comes back to this point I'm asking rhetorically. What was he doing misrepresenting to Tony Trolley, which he has not answered in our founding of the day, when he knew on the 12th of March that on the 1st of May, this increase comes into operation? What were they trying to achieve when they said there is 30 days from which you can come back and redebate the issue? So I'm saying that deception is anti-constitutional.
But is it not so, Mr. Nkatobi, that it ultimately was in the hands of Parliament?
Well, it is still, technically speaking, now in the hands of Parliament, right? What I am suggesting is that even in Parliament, if a vote is procured through deception, it is still unlawful. You could say that it is a matter of politics, and you've already said so, Justice Savage. But I'm not sure what that means.
That's a question. I'm not a politician.
Yes, I'm not sure, Justice Savage, what that means, because there are several candidates about what that statement might mean. The one is that South Africans must accept that politicians will lie in the course of doing business. I don't have a problem with that. I have a problem with it when they're discharging constitutional functions. But if they're sitting in Lutuli House and lying to each other, there's no problem. But what we are dealing with here is a matter of immense national importance.
Do we not know that what was occurring was the ANC was needing support for its budget? So it was looking for supporters. It was looking for support from other political parties.
Yes.
So that was part of the process, was trying to secure them.
It is absolutely clear. That's what they were trying to do. The problem
But there's nothing wrong with that, but they shouldn't deceive the public.
Precisely, because the contamination with deception is in the report itself. Because it's the report that says we're coming back in 30 days. So once the report is contaminated by that deception, then it is unlawful. It cannot be given legitimacy by the court.
I just want to understand, there's two players here. We're talking about deception by Parliament or the committee, and the deception by the minister.
Yes.
So the one you're dealing with is the deception by the committee.
Yes.
And is that, did the committee actually understand? Didn't they think that, well, ministers must still come back to us? Is it a matter of deception, or is it a matter of maybe misunderstanding the legal framework or the 7-4 powers that the minister has?
Well, there are two candidates to this. Maybe the two of them are together. Certainly on the minister's side, who now claims that I've made my decision, it comes into effect on the 1st of May, a case of deception can be established. But when it comes to what were the parliamentarians doing when they included in the report that this matter will come back, were they trying to deceive the public, or were they genuinely confused? If they were genuinely confused, it's still irrational.
No, I get your point. Thanks.
Now, so we will submit, therefore, that on both of those two grounds, there is a substantive unconstitutionality problem and a deception stroke grave confusion. Both of those contaminate the VAT rate increase so significantly that it cannot be given a stamp of approval by this court. That takes me then to the last of the three. That takes me to the last of the three, which is what actually happened in the committee. So the starting point here is section 8(4) of the Management Amendment Procedure Act. So the section states the following. So section 8(1) starts by saying that the National Assembly and the National Council of Provinces must refer the fiscal framework and revenue proposals to their respective Committee on Finance. So there's a clear obligation that it must go to the Committee on Finance. Section 8(2), the committees must conduct joint public hearings on the fiscal framework and revenue proposals. Section 8(3), the committees must, within 16 days after the tabling of the national budget, submit a report to the National Assembly and the National Council of Provinces, as the case requires, on the fiscal framework and revenue proposals. And then section 8(4), the report must include a clear statement accepting or amending the fiscal framework and revenue proposals. So there seems to be three distinct duties. The first is the National Assembly duty to refer the fiscal framework and the budget to their committee. The second duty is, once it is in the committee, there is a duty to conduct joint public hearings, both on the fiscal framework and the revenue proposals. And it must be tabled to the NCOP, but when it is tabled, that report must include a clear statement accepting or amending the fiscal framework and revenue proposals. The EFF's case on this score is twofold. The one is to criticize the process of deliberation that took place at the committee itself. That process of deliberation was farcical. Now, if your ladyship and my lord go through the document I handed up, you will see a comparison. I think it's the 8th page. You will see a comparison drawn from the figures of what we say happened at the committee. And there are 10 items that have been isolated there. And what the speaker says and what the minister says. And so we've classified this in the heads of argument as absence of deliberation, and we've cited various constitutional judgments that show that the heart of Parliament is a deliberative assembly. So there has to be a meaningful engagement and a meaningful participation in the substance of what is presented before them. So the first one is that the criticism is that there was a request to the speaker by the EFF.
Paragraph? Which paragraph?
Well, it's the first paragraph, paragraph 12. These are not numbered, but they are in table format.
Okay.
So
This is the letter that was sent to try and stop the vote.
to try and stop it, yes. Which is admitted, but the minister says nothing about those. But the point here that is made is simply this: these are not the irregularities were brought to the attention of Parliament. It is not as if Parliament was unaware of the irregularities of the committee that were brought to its attention. So it approached this task with its eyes open about the problems. So it therefore accepts it. I know that the Speaker of Parliament responded to the DA and said that her advice is that there were no irregularities. That's all fine. But the point here is that if there were irregularities, these were brought to the attention of the Speaker prior to the vote. And so when they voted, their vote was to endorse those irregularities, which is not allowed by the Constitution. Then the second allegation that is made is this, and I think it was debated when Mr. Bishop was arguing, which is However, this conclusion and the insertion in the impugned report, that's the insertion of the word accept, was done post the sitting of the Finance Committee and was not in fact deliberated upon and concluded by the Finance Committee, despite Sinawo Tambo, who is from the EFF, having proposed at the beginning of and halfway through the sitting that the Finance Committee starts off by taking a position on whether it accepts or wishes to amend the fiscal framework, which would in turn inform the report it was seized with, not the other way around. Now look at what the answering affidavit says of Parliament in the next column. It is correct that the insertion was made post the sitting of the committee. I refer to what I've stated and maintain that it reflects an accurate account and statement of what occurred at the meeting. The remaining allegations are denied. Now that allegation is very important because she never identifies where the item that is being voted on, accept or amend, is ever presented to the committee during the deliberation to vote on. Never identifies that.
It's common cause, it was not there.
It was not there. But what is concerning is the bold denial by the Speaker, who is herself a repository of public power, where she admits that the insertion came afterwards. And then there is a third, and again, this is not a technical fight, it's a fundamental element of Section 8.4 based on the rule of law. They have been given a power, and the Parliament has decided this is how the power is to be exercised. But they themselves, as lawmakers, are just deciding to ignore it. And then,
Mr. Nkatobi, in that regard, it's also common cause that on the same day of the report, the 1st of April, both the EFF and the DA, their representatives from the committee email the secretary of the committee and say that's not what was agreed in the committee.
indeed,
And this report does not accurately reflect the situation.
yes, indeed.
And the following day, in spite of that, and in spite of then letters to the speaker, both by the DA and the EFF, to say don't go ahead with the vote.
Yes.
It's rushed through and the vote's held.
Yes, they ran through. They thought we've got this gap now because Action SA is with us. Let's put it through.
Arguably, there would be a basis in which to say that an issue could be discussed by a committee, and the report could be a correct reflection of that report after the fact could then be sent to Parliament. In certain circumstances, fact dependent, that might be acceptable. But in this case, the facts show completely the opposite.
Yes, the facts show that the report was a distortion of what had happened. And that distortion was brought to the attention of the Speaker. The Speaker nevertheless ignored it.
What is to be made of the word approved in the minute?
Whatever that word means, even if it means accept, it is still undermined by the condition, which is also included in the report. Because the section says clear statement, and once you put the condition, it takes away the clarity. So it's the main argument, by the way, by the Speaker, is to say sometimes they use approve, sometimes they use adopt, but they always shy away from accept, which is the language in Section 8.4, because they know that accept is not conditional, even in contract. If you say I accept, but that's not an acceptance. So the third irregularity is then identified in the following section, which again is objections being raised, and when you look at the answering affidavit, that's not being addressed directly. And then the fourth one, there is a fifth one, okay, a sixth one, again no answers. A seventh irregularity, an eighth irregularity, and what you say is the content hereof is denied, the content hereof is denied, the ninth irregularity, and the 10th irregularity. So we've taken the time to go through this quite carefully, and we've come up with 10 irregularities which simply cannot be answered. So I'm afraid what you have, what the court has, is that it has a report that is so fundamentally undermined by the irregular way in which Parliament conducted itself, which is in conflict with Section 8(4), and therefore cannot be given effect. What that really leaves is, well, can you do the separation? We've showed in our heads of argument that you can't come and rely on a different section after the event. If the minister's case was always, I'm increasing VAT, I don't care about the budget, and I don't care about the fiscal framework. That was never his case. That case came in the answering application. So, therefore, he was always trying to increase VAT as part and parcel of the budget and the fiscal framework. So he's bound by that election. Then, well, what is the court supposed to do? Well, we submit that it's inevitable that relief must be given to the EFF and the DA. The question is whether interim relief on the fiscal framework or final relief. We've asked for interim relief. Mr. Bishop, as I understand him, says that interim relief might not be appropriate because it would sterilize parliamentary processes until Part B is ready. It's unclear to us why it would, because if the current process is interdicted, it's clear that they may not proceed with it. But that doesn't mean they may not start a new lawful process.
Can I just ask paragraphs 3 and 4 of the relief, which suspend the report of the standing committee and then the reports of Parliament after that? Has the boat not sailed in respect of that report? What would the suspension of the report do? Because that has already been, that's gone through the process and voted on. And so what would the suspension of the report of the standing committee do at this stage?
Well, my lady, we do ask in paragraph 4 for the suspension of the National Assembly resolutions. What we were worried about is that the court might say that there was nothing wrong with the National Assembly resolutions, and therefore we have to attack both of them. But again, if you only gave us paragraph 4, theoretically, you still have the problem that you've got the poisoned report of the standing committee, which still remains and has not been suspended.
I think my question goes to, is it not the setting aside that should be granted rather than a suspension? Because a suspension,
yes.
what does it really do?
Yes, it may not be just an equitable. Let me just say this. The relief that should be given is just an equitable under Section 172, and that's what Kodan says. And also says that you are not bound by my formulation of the remedy. What you must give is what is just and equitable.
So if it was final relief, you would be covered.
Yes. That would be given. I submit that I do meet the threshold for final relief, but we had asked for interim relief. But the fact is that the facts are so clear and the law is so clear that the court will be entitled to give final relief in its discretion. If the court gives final relief to the DA, then my arguments are only supplementary to the DA. I don't need separate final relief.
Okay. If, for instance, we give final relief to the DA, and then paragraph 5, which is the interdict, would still stand. Is that right? Is that what you're saying?
Yes.
So in respect of 3 and 4,
yes,
we can actually give the final relief in respect of that, but paragraph 5 still stands because that's the interdict pending Part B.
Yes, indeed, because there is Part B even on the DA's formulation of the case. But I still need Part B anyway because I need to finally set aside the VAT increase.
Okay. So Part B in this instance would only be in relation to the VAT increase and not the report, because the reports would have been catered for in the final relief.
If you give the DA final relief, then I don't need any final relief. My arguments will simply support what the DA has said.
Okay.
But it's in that event that you think final relief is inappropriate that I say my paragraph 4, 3 and 4 are appropriate.
Okay.
I have nothing else to add.
Costs,
Well, there are 4 of us. We should be entitled to cost of 2 counsel. case is sufficiently complex. We are immunized from costs by Biowatch.
Yes, we can start according to 2.
Thank you, Mr. Ngugaitobi. Can we perhaps break early, now at 1:45, come back at 1:45? We'll make arrangements that you come in, you're allowed to come in at 1:45. All right, quarter gents until 1:45.
Oh, no.
Thank you. Ms. Silo, you have your 10 minutes first, uninterrupted, and thereafter we'll ask.
I'll try and use my 10 minutes. Okay.
Yes.
I have a structure that I was going to follow, but before I do so, I think it is important perhaps to dispose of one issue that is creating confusion in the report. And this is in relation to submissions made by the EFF. The EFF addressed the court on the alleged deception by the Minister of Finance. But most importantly, the EFF suggests that they pleaded that case and it was unanswered in the Minister of Finance's answering affidavit. That is incorrect, and I would just like to give the court the references where this issue is dealt with. I'm not at this juncture going to deal with whether or not what the EFF understands to have happened constitutes deception, but I'll address the first one, whether it is dealt with. Firstly, it is in the Minister's affidavit, starting at paragraph 80, and it will be some paragraphs 80.1 and 80.2. As well as at paragraphs 48 and 50. The sum total of the Minister's response is firstly to deny the word deception on his part, secondly to rely on the actual speech that he made on the 12th of March, which is to be found, and that he states in paragraph 18, the whole speech is reflected there. A comparison of the speech and the allegations by the EFF will demonstrate that there was no deception. What the EFF relies upon is what Mr. Trolley of Action SA supposedly communicated, I think, to the public as to what the minister said. The minister in the affidavit denies that those were his statements. And in fact, he states at paragraph 8.2 that he doesn't assume responsibility for any misunderstanding that Mr. Trolley may have delivered. So I just wanted to address that issue and point it out that it was dealt with definitively. Getting back to my structure, my ladies and my lord, this, at least for part A, is, on proper reflection, a fairly simple case. It revolves around the proper meaning of section 7.4 of the Act, which of course must be read with section 7.1.
You're now referring to the DA's case, not the EFF, right?
No, I apologize. My correction to the EFF is done. I am now making my submissions.
Okay.
So I say the entire case, whether brought by the DA or the EFF, revolves around the interpretation of those two pieces, those two sections. We do make the point that the EFF, in its papers and notice of motion, does not challenge the decision of the minister per se. And the basis for that is, as pleaded and is argued in the heads of argument, is that their understanding is that decision is intricately linked to the parliamentary process arising from the portfolio committee. We submit that the EFF is wrong. The legal opinion that the DA references in their founding papers, that they indicate they received, having been labored under the same misconception, is the correct legal position. Those are two distinct processes with two distinct outcomes. Hence I say, today is all about the proper interpretation of 7.4 and 7.1. I will address the question of the claim of unconstitutionality of section 7.4, only insofar as the DA relies on it to demonstrate that it's got prospect of success in Part B. And I will demonstrate that it doesn't actually have prospect of success, because the unconstitutionality they argue for is non-existent. I'll thirdly then deal with the essence of the applicant's case, both of them, but more the DA's case when stripped of all the frills. And lastly, I will address the question whether or not, against the background of my submissions, it can be said that the DA has made out a case for the relief it seeks in Part A, whether one calls it a suspension or an interdict, because the grounds for both are the same. Looking at Section 7.1 and 7.4, the DA departs from the premise that the minister, acting in terms of Section 7.4, imposed a tax. And that is incorrect. The imposition of that tax, which is a value-added tax, is in terms of Section 7.1, such that in the absence of 7.1, there is nothing the minister can do or ought to do in terms of 7.4, because he requires the VAT to be in place, having been imposed by the legislature, before he can deal with the rate of that tax. We know that the DA contends that the exercise of this power is to the minister has the effect of usurping the authority of Parliament and constitutes an impermissible imposition of tax. It is precisely that position that I submit the DA makes, because it conflates what happens in Section 7.1 and what happens in Section 7.4. That imposition of a tax is done long before 7.4 is called into use. It is appropriate at this juncture to consider the entire budget process in its proper context. And I submit that that process starts at Section 27 of the PFMA. Section 27.1 obligates the Minister of Finance to table an annual budget for the financial year in the National Assembly before the start of that financial year. So it's got a period when it must happen. Secondly, the annual budget must be in accordance with a specified formula. It's not recorded for our purposes currently, and must contain at least proposals for financing any anticipated deficit for that financial year. That's in terms of Section 3, sub G. So the budget will deal with all aspects, revenues, expenditures, and everything. Should there be a deficit identified in that budget must indicate proposals to finance specifically that deficit. Section 7 of the Money Bills Act tells us that in tabling that annual budget, and that is Section 7 of that Act, the minister must present a proposed fiscal framework and tax and other revenue proposals. Those revenue proposals in Section 7 of the Money Bills Act are the very same proposals for financing the anticipated deficit contemplated in Section 27, 3, sub G of the PFMA. So, working on either act, it is unavoidable that the Minister of Finance, to comply with the act, where there is a deficit, firstly, he must indicate all sources of revenue, and where there is a deficit, he must put forward proposals to address that deficit. As we know then, in this budget 2025-26, in response to the requirement contemplated in Section 27, or imposed by Section 27, 3G, the Minister proposed a VAT rate hike of 0.5% for the financial year 2025-26, with a further 5.5% for the next financial year, cumulatively 1%.
I think the 10 minutes is up.
Thank you.
Okay, you can continue.
We submit that in so doing, the minister at least did the basic, the first, which was to comply with the provisions of both the PFMA and the Money Bills Act.
Can I just ask a question?
Yes.
Since this is the entire scheme, it's a whole scheme starting with Section 27 submission.
Yes.
What happens if at the end of it, the Parliament votes down or doesn't adopt the fiscal framework, and all of it everything that's in there falls away because it's not adopted. So what happens? Can the minister continue with the announcement made in respect of the alteration of the VAT rate?
My response to that question is, Helen will recall that the minister must prepare a fiscal framework, and in terms of the law, once presented to Parliament, Parliament must then direct that fiscal framework to the appropriate committees, including the Finance Committee,
Yes.
for comment and deliberation. In terms of Section 4...
In terms of Section 8 of the money for acceptance or amendment.
Indian money.
Mm.
Yeah. So in terms of Section 7 of the Money Bills Act, if I can find it...
So what if it's amended? Maybe my question should be rephrased. What if it is amended and amend the VAT rate itself? What happens there?
What ought to happen, on my understanding, is if we go to Section 8, I've gone offline a bit, I apologize for that. If we go to Section 8, and that's the section dealing with the adoption of the fiscal framework.
Yes.
Subsection 6 of that section informs that if the report includes amendments to the fiscal framework or revenue proposal, then the amendments to the revenue proposals must comply with Section 11.3 of this Act. The minister must be given at least 2 days to respond to the report and any proposed amendments prior to the submission of the respective reports to the Houses. And lastly, the respective reports of the committees on finance must include the responses to the minister. Now, if we understand that is the framework,
yes,
it would suggest that the Finance Committee would debate the fiscal framework. It would accept or amend. It's the effect of any amendment. Those amendments must be put before the Minister of Finance for his consideration and response. His response then constitutes part of the fiscal framework, which in terms of Section 8 sub 6, both will serve before the National Assembly.
Yes. Now, what happens if there's a flaw in the sense that the process that you're articulating did not take place as it's supposed to in terms of Section 8? What happens to the announcement, the submission by the minister?
That announcement and its effect sustain until Parliament has voted on the Act to amend the Act to increase the VAT to 15.5%. And it is because of the wording of the Act that provides that amendment or that change sustains and subject to engagement by Parliament of that. And that is the reading of Section 7.4 itself. It subjects that increase to confirmation or rejection, as the case may be, by Parliament. So,
sorry to interrupt you, but at this stage, my understanding is that we're dealing with a fiscal framework. So Parliament must, at this point in time, if the minister announces a VAT rate increase in the fiscal framework, Parliament must then debate it after it has gone to the various committees.
Yes.
And if Parliament decides, well, we don't need a 0.5, we need a 0.4, what happened then?
Then the VAT will be increased by 0.4 because the eventual decision is that of the National Assembly.
But it doesn't, in terms of the Act, is that, in terms of the Constitution, we put it differently, it's only the minister that can introduce a money bill.
Okay.
And the money bill has not been introduced yet of 0.4. When is he going to do that?
It's a 0.5% money bill.
Yes.
Money bill. And the Parliament, in its legislative processes, is entitled to consider that proposal in the money bill, adopt or amend.
Can I just come before that, if you don't mind? Because I'm just wondering, to follow up with what my brother is asking, at this stage, we're still going through the process, the Section 8 process.
Yes.
And are you saying that if Parliament says the report, the committees, and then Parliament endorses it, that we don't want 0.45, we want 0.4? Are you saying based on that amendment at that stage, then the announcement by the minister will be trumped by that amendment
Indeed, so, Madam.
without legislation in 12 months' time?
We
No,
need
the
to find that
legislation is, no. Let me correct myself. What will trump is the passing of a legislation that imposes 0.4.
But that's too early. So if the amendment by the National Assembly is 0.4, then the 0.5 cannot proceed.
It does.
Because the fiscal framework has now been, there's an agreement on the part of it's resolved, the National Assembly, that a 0.4 VAT increase must be effected. Therefore, the fiscal framework, there's an amendment that has been resolved.
Can I take a step back, my lady? The minister suggests in the fiscal framework 0.5. The portfolio committee considers the fiscal framework. It makes its own recommendations, which are put before the Minister of Finance, who considers them, and that whole lot serves before the National Assembly. So when the National Assembly debates, firstly, the notion of VAT increase and the rate, it has the benefit of all views, and it's open to Parliament to decide.
At that stage,
At that
regardless
stage.
of 7.4 announcement,
Malady,
regardless of what was said by the
regardless of
minister.
what was said, however, because of the nature of Section 7.4, which has technically amended the rate in 7.1, to correct that amendment, then Parliament must pass that money bill.
But that's down the line.
That is down the line.
But what happens from the 1st of May if
Then
Parliament
then
had...
the minister's determination must subsist.
That's what I'm saying. I'm
Despite
trying to
Parliament.
ask. Despite the 0.4 amendment,
Because of the effect that decision has, it has already amended the Act.
How can that be, Ms. Sero?
And that's the point I'm coming to, my lady. Whether or not that is possible. We submit, yes, it is. And that is the case I seek to make to this court. So if, for the moment, the court were to accept that the effect of that announcement is to amend that Act, then that Act has to be amended. If eventually the decision is 0.4, and to amend that Act, Parliament will have to pass the money bill.
But what is the purpose of the fiscal, of Section 8.4 of the Monies Bill Act?
The purpose is to give, and I think it's stated in the Act, the opportunity to engage with the views, the suggestion, the basis upon which the proposal, in this example, to increase the VAT by 0.5.
The purpose is to accept or amend the fiscal framework.
No, my lady, it is not for the portfolio committee to accept or reject. That is for Parliament to do.
but
So-
there must be a clear statement, though, by
Well,
then.
that is a statement, that is a parliamentary requirement.
So that it goes to the committee and they must then make a determination as to whether they accept or amend it. And then it goes to the National Assembly.
Indeed.
The National Assembly then decides whether it resolves to accept or amend. As I understand you, if they resolve to amend, that matters not, because the minister's going to go ahead anyway,
If
because
who-
7.4 permits the minister to
If who
do so.
resolves, my lady, the
If the
portfolio committee.
no, Parliament.
Yes, if, let's say, the portfolio committee suggested to amend, and Parliament adopted the minister's proposal, it will be 0.5. Because the eventual decision.
No,
No.
the other way around.
No, I'm starting with that scenario. The second scenario is if the portfolio committee rejects 0.5 and recommends 0.4, and Parliament adopts 0.4. That's the scenario where the issue is
That's
made.
correct.
Yes.
The question is, has that affected the 0.5 adjustment
Yeah.
made by the minister in terms of Section 4? And we submit not.
Then what is the role of Parliament?
The Parliament has to engage with that money bill. That reflects that.
Within 12 months.
Within 12 months.
So what if we have a reckless Minister of Finance who decides it's going to be a 25% VAT hike?
Then it won't be a reckless minister, it will be a reckless National Assembly.
No, because on your argument, the Minister can go ahead regardless of what Parliament says.
The DA made a submission that that bill can be passed, I think on their estimation it was June, July. The process is you can only amend an act with an act.
But
No.
what I'm saying is,
Except for, that's a peculiarity of 7.4, which I want to get to now.
but how can we accord such power to a minister in circumstances where the raising of revenue is ultimately for Parliament?
May I park that question? I'll get to it because I want to, it stems from the notion of unconstitutionality that is pleaded by the DA. And perhaps if I work through my argument, we will get to that point where I address an issue directly, that answer. And I will get to that answer because this is what it's all about. On the question of unconstitutionality, the first case, and it's not in our hands, we invoke this in response to the DA's head of argument, where they rely on Smith, Casino Association, and Mutlaba. In order, and our submission is that those are distinguishable. In order to understand why we say they are distinguishable, we must go back and start with the certification case. In 1996, 744, and we know that's a constitutional court case. That case engaged the principle of separation of powers. And it highlighted that our constitutional dispensation is such that we do not recognize absolute separation. At paragraph 109 of that document, the court highlighted that the principle of separation of powers recognizes the functional independence of branches of government. On the one hand, the principles of checks and balances focuses on the desirability of ensuring that the constitutional order as a totality prevents the branches from usurping each other's power. In this sense, it anticipates the necessary or unavoidable intrusion of one branch over the terrain of the other. No constitutional scheme can reflect a complete separation of power. The scheme is always one of partial separation. And that's our starting point. Accepting
But
that.
are you suggesting that raising taxes, in the true sense of the word, is that now dual power, part of the legislature and part of the executive?
Raising taxes, no. The section 77, I think, of the Constitution tells us only a legislative body may raise tax. And we say that has already happened in section 7.1. What we are dealing with here is the rate of that tax determined by the legislature.
But it's being raised to 15.5.
It is the rate that is being
Raised.
May I say, perhaps sometimes it does get to be a bit confusing when we speak of raising tax. The appropriate, I think, phrase to use is imposing tax. I accept, I have no difficulty that only the legislature can impose tax. Well, that's section 77 tells us so.
Now, what did the minister do on the 12th of March?
What the minister did was to adjust the rate of the imposed tax in terms of section 7.4. And that is the distinction that cannot be overlooked.
Raising revenue. Wasn't that raising revenue?
It was. Well, the effect of it would be to raise revenue for the National Revenue Fund.
Yes. So
And
isn't that a legislative power?
And that is why at the time of the budget, he filed simultaneously with the revenue bill, the money bill adjusting, in order to amend section 7.1, where it stipulates a tax of 15%.
But what if you do get a minister that don't do it?
Madam?
Sorry, what if we do get a minister that don't do it, file it simultaneously?
It has to be done. That is imposed by section 27 of the PFFA. Together, I think, with section 7, it stipulates what must be submitted at the point that the minister submits, announces his budget in the National Assembly. If he doesn't, it's non-compliance. And Parliament is entitled not to consider that proposed budget. So it would be a clear case of non-compliance with applicable legislation. And, if the
But the announcement will still remain.
Man,
His announcement will still remain
Well, I
in
doubt
terms of
his-
Section 7.4.
His announcement will remain because I doubt whether his budget will serve before Parliament for him to present the budget to Parliament when he makes those announcements in Parliament. So if his budget is non-compliant, that budget won't serve before Parliament. And it is only at that point where he presents the budget that he's got the opportunity to make that announcement. So Parliament ought to have satisfied itself. I don't have the reference now, but I would expect Parliament to satisfy itself that the budget that the minister intends to present on the 12th of March is fully compliant with applicable legislation.
Can the amendment by Parliament to 0.4 coexist with the minister's proceeding of the amendment of the announcement in terms of Section 7.4? So if Parliament says we want 0.4, but legislation has not yet been enacted, can that coexist with the current 7.4?
If Parliament were to be of that view, Parliament would have to take steps to stop the efficacy of the minister's decision. And those steps is promulgating an act.
But Parliament can't do it. It's only the Minister of Finance that can introduce a money bill.
It is already before Parliament.
No, but that's a 0.5.
That's 0.5. And
We're talking here if Parliament decides it's now 0.4. What's happened then?
Parliament may propose to amend it, which would mean that the money bill presented to Parliament for deliberation and adoption is not adopted at 0.5, it's adopted at 0.4. Continuing on the question of constitutional, absolute constitutionalism, I'll only have reference to Museneke DCJ in Shuttleworth, where he reiterated the point that we must start by recognizing the fact that our constitutionalism does not insist on an absolute separation of powers between the three arms of the state.
Which paragraph, sorry, of Shuttleworth?
I'll ask my junior to find it for me, I apologize.
Okay.
I'll find
Okay.
the actual paragraph.
You can proceed.
In the case that arose from the Western Cape, I don't have the full citation here, and I'll ask my junior to get it for me. The Constitutional Court was dealing with the question of a Section 16A of the Transition Act, which the President had published in a proclamation. The effect was to alter the structuring of the government. And at paragraph 65, the Constitutional Court noted first that no constitutional scheme can reflect a complete separation of powers. But even accepting that, the provision that was challenged at the time was overbroad and trammeled as it empowered the President to amend the Act and its schedules. In simple terms, it granted the President the unfettered power to amend its primary terms in any way he deemed fit. And that's at paragraph 65. And that is the distinguishing feature we submit between Section 7.4 in this case and what was then Section 16A of the Transition Act. In the certification case, Mohammed DP agreed with Charles Carson, who penned the majority, who penned the judgment for the court, and he highlighted specifically that the delegation of lawmaking authority from Parliament to the executive is necessary for expeditious and effective lawmaking. These comments are made in paragraphs 127 and 128, and concluded on the certification judgment, and concluded that Section 16A went too far and effectively constituted an abdication of Parliament legislative function at paragraph 144. In this regard, Sachs Jane, agreeing with both Mohammed and Charles Elson, provided a useful guide as to whether in our environment of partial separation, what can be done to ensure that once, I won't call it encroachment, once one arm of government exercises a power that under absolute constitutionalism would be unlawful, what must be guarded against. And he gave a list of factors to be considered, which would be helpful in determining the legality or otherwise of that exercise. And in this regard, he listed about 7, pointing out that they are not, the list is not exhaustive. The first was the extent to which the discretion of the delegated authority is structured and guided by the Enabling Act. We submit that 7.4 specifically stipulates that it is subject to Parliament, minister's exercise of his power to adjust the VAT rate is subject to parliamentary adoption. So it will comply with that requirement. The public importance and constitutional significance of the measure. The more it touches on a question of broad public importance and controversy, the greater will be the need for scrutiny. In this regard, we say the amendment is introduced by way of a money bill, to be debated, adopted, and amended by Parliament. The third is the shortness of the time period involved. Section 7.4 compels Parliament to engage with the ministers as a quote-unquote amendment. It's not a choice for Parliament. And it must do so within a period of 12 months. So if it passes a money bill for 2 months, within 2 months, that approves 4%, then the VAT rate will be 4%. If it waits until 12 months or 10 months, then the ministerial decision must prevail until Parliament has made that amendment.
But it's my understanding is, and please correct me, is that when the minister made the announcement on the 12th of March,
yes, ma'am,
he indicated that from the 1st of May, it will come into effect. Now, thereafter, the money bill gets introduced, it appears, and also thereafter Parliament gets engaged. Now, if Parliament, during that process before the 1st of May, come to the conclusion that, look at all of this, this is the fiscal framework, we accept in terms of certain of the expenses and how much money the National Treasury can get for us, but we have the view that it must be 0.4%. What's happening from the 1st of May?
Then Parliament must pass an act adjusting that to 0.4%.
But we know that they won't be able to do it before the 1st of May.
I think it was suggested that they could do it by June this year, which would be a month after the 0.5%.
Now, what's happening during that month period?
0.5 applies, madam. I mean,
But can that ever be? If Parliament has decided that we don't agree with the minister, it must be 0.4. So what's happening, sorry to interrupt you, what's happening is that the executive has taken over the power of the legislature, even whether it's for a month.
what happens in
Can that be tolerated under our constitutional scheme?
Indeed, my Lord, we submit that it can be tolerated, and it must be tolerated. Because Section 7.4 grants the minister, delegates that power for a limited period, and subjects the exercise of that power to parliamentary oversight. And our constitutional court has accepted that that is a proper delegation of authority. The difficulty arises where parliamentary oversight that no longer applies.
But my understanding from what you've said so far is that the imposing of tax remains in the domain of the legislature.
Of tax.
Yes. Now,
For instance, my lord, I think the EFF suggesting a imposition of a wealth tax and the like. That is purely the preserve of the National Assembly.
yes, but raising VAT, is that also not part of raising revenue?
As raising VAT in terms of adjusting the rate or
Yes.
imposing a...
Well, whether you want to say raising or when you say imposing, let's say imposing.
Imposing VAT is a function of the legislature.
Good. Now here the minister makes an announcement of 0.5. The legislator said, no, we're not agreeing with the minister, it must be 0.4. But his announcement trumps that of the legislator,
And
even if it's for a month.
it is because the act of the minister amends that act.
Okay,
Now,
so
we will get to the point whether or not that is constitutional, and that's the one I'm trying to.
so can I just get that last point? So you concede that it amends 7.1.
The rate in 7.1.
So the announcement as altered, or the alteration of the minister amends 7.1. You
Yes.
concede that.
Insofar as the rate is concerned, I do.
Okay, just to follow up another point there. So if Parliament says, hang on, we are not happy, we want a different rate because this one is unlawful. Let's assume that its reason for not accepting it is a constitutional reason or a reason based on it's unlawful. Now, and the minister goes ahead based on 7.4, can that happen?
Then the Parliament must pass an act to undo, quote unquote, the increase by the minister, because that increase has affected the rate contained in section 7.1.
Even if it's raised unlawfulness within the month before the legislation is passed? Even if it's raised an issue of constitutionality within that month period?
If Parliament has...
If Parliament has raised that, minister, we think that this rate that you're imposing is unconstitutional or unlawful based on ABC. Now the minister says, well, even if you are legislature, but based on 7.4, I can continue to go ahead.
Because because of 7.4 and its wording, you must pass an act.
So your answer is yes, it must go ahead.
It must?
It must go ahead.
What must go
The
ahead?
7.5 must go ahead, even if there's unlawfulness or unconstitutionality.
7.5.
On this question of my sister.
It's not a question of if there is unconstitutionality, then we must rush to court and come and address that unconstitutionality. In which event then it would be invalid and unlawful.
But that is why the DA and the EFF is here.
And they are here, and we say they are here. It's wrong that they are here because what is happening in 7.4 is not unconstitutional. And that is the argument I seek to persuade you on.
Okay.
It is not unconstitutional. And I will distinguish both Smith and Mohamba to demonstrate that it is not unconstitutional.
So is the oversight role on that scenario of Parliament not curtailed in that situation? Because if Parliament can raise and say, well, as a legislative body that's entrusted with tax imposition, I'm unhappy because this is unconstitutional. But then the statute grants power to the minister to go ahead anyway. Isn't that curtailing the supervision, the power of Parliament in that situation?
To answer that question, may I request my junior to look up something and I'll revert my name immediately. It was to check precisely that question, the question of whether or not it's open to Parliament to reject the framework, the fiscal framework, or the understanding of the current legislation. It stated that Parliament can only amend that framework. The question then that arises, I think, from her ladyship, is what if they amend to 0.4? What is the status of the decision of the minister? And I submit that it stays at 0.5 until that money bill is promulgated.
Okay.
Now, going back to the factors that SACS J proposed to be considered in the certification judgment, one of those important is to consider the degree to which Parliament continues to exercise its control as a public forum in which issues can be properly debated and decisions democratically made. We note that in their case and in their argument, the DA doesn't spend what we propose as sufficient time on the phrase subject to set out in section 7.4. It is the meaning, import, and impact of that phrase. And if I can give the court the citation, S versus Marwani.
Is it in your heads of argument?
It's not, my lady, that's why. And we've prepared the copies here for the court.
Yes, please, can you help?
They're being distributed.
Thank you.
The first is State versus Marwani 1982. And in particular, I would like to refer the court to page 747H to 748A.
747H.
To 748A. And in that case, the appellate division pointed out that, as the court found it,
Yes.
the word subject to, in that context, refers to the provisions of this constitution in a particular section that was challenged. And the court held that, considered the purpose of those words, and said the purpose of the phrase subject to in such a context is to establish what is dominant and what is subordinate or subsidiary. That to which a provision is subject is dominant in case of conflict over that which it is subjected to. This ratio was recently adopted as well. And the second case I have provided, that's Zanzi versus Council of State. It's a constitutional court judgment.
You don't have a copy of
We
that?
have two judgments, two cases.
Okay, we have one. Only Marwani.
There's an error happens with distribution.
Okay.
There should be two, that and one for Zanzi.
No problem.
And in Zanzi, I would specifically like to refer the court to paragraph 27, which considered the ratio from State versus Marwani, and concluded that as to its meaning, he agrees and adopts what Miller J.A. stated in that passage at 747H to 747A. Other courts have also adopted that meaning. And just to point out, Chevron Engineering, I'm not relying on it, 2003, 5, SA 206.
Sorry, where are you now?
Now, I pointed to State versus Marwani, I gave the protocol.
Yes, we
And
there.
then to Zanzi.
Yes.
And I'm just highlighting other cases where that dicta in Marwani has been adopted as correct.
Okay.
And it's really useful in a matter like this to have this in the heads of argument.
My lady, this was necessitated, I do apologize, by the posture assumed by the DA in their heads of argument, in reliance on Mashoba, Casino Association, and Smith. And we realized that we had not dealt with these issues in our heads of argument. And in order to address that aspect of the argument, it became necessary to lay the foundation on why we say that they are distinguishable. And we do apologize for the oversight. We will upload the cases with the leave of the court. as soon as we can.
Having read this, what is the point you were trying to make?
The fact that that phrase, subject to, is what assures parliamentary oversight and control. And that is what leads us to the case of, for example, Matroba. Perhaps if we go to Mutraba.
Is there any contention on that? That it is subject to parliamentary oversight at that stage?
Yes.
Not at the stage, not in between the announcement becoming effective and the legislation being adopted. So in between, I think that's where the contention lies.
And we do appreciate that, except if that is the case, then Mutraba, Casino Association, and Smith will not assist the court because they did not have parliamentary oversight. The impugned sections were definitive, and once that power is exercised, the legislature and parliament didn't have oversight to reverse what was done in terms thereof.
But what happens to the public in that period?
Confusion in public and
Meaning the democracy that I think my brother spoke of earlier in the morning, that the public that is supposed to be entrusted with this via the legislature, what happens to them in that meantime?
the 0.5% will apply. And as
But isn't it there where the difficulty lies? Because if Parliament still have to reconvene and discuss and debate and vote on it, the Minister's recommendation for a VAT rate increase stands, even at the displeasure of Parliament. So how can we ever, within our current democracy, allow that the executive is dominant in that respect?
I don't think that the executive is dominant. In the certification case that I referred to, the Constitutional Court recognized that it does become, at times, imperative that there be a speedy execution, and that which Parliament does not have by its nature. So therefore, the law must allow for the speedy execution subject to Parliament exercising its oversight over that decision. And that comes from the certification judgment, my lord.
Just on that point, Mr. Bishop says this is not an emergency where you are reacting and you have to implement something speedily as the minister, but it is a process. It culminates from the process of planning the budget and all that. So it is not something that, oh, there is an emergency that we now have to respond to.
Well, I guess the question of definition of emergency. It becomes apparent during the process of during the budget process. From paragraph 20 to paragraph 40 of our answering affidavit, we set out the process, the budgeting process, culminating in consideration by cabinet and approval or disapproval by cabinet, in which event it has to be amended. In that process, the deficit has already been recognized, and the deficit is quantified and must be addressed. So it becomes an emergency in a sense that at the time it is tabled and the deficit has become clear, then that deficit must be met speedily. And the only way, at least for purposes of our argument here, is that in his wisdom, the Minister of Finance found that the adjustment of the VAT rate by 0.5% will address that deficit.
But on that score, what must we make with the argument by Mr. Nkatobi, where he said, if one have regard to what's been discussed in the commissions, I mean, the commissioner says, listen here, if you fund me properly, I will be able to go to certain areas where we can definitely get more taxed from high net worth earning individuals, companies that hasn't paid properly their taxes, etc., etc., etc. So what must we make of that?
Then we are
So it appears what the commissioner says, although he abides with Part A, is that if you fund me properly, I will be able to get the money necessary. So it's not, there's no need for a VAT increase.
Then we are in the realm, my Lord, I submit, of preferable choices. We are in the world now of, is it open, for instance, to the court or anyone to suggest that of various options available to the Minister of Finance, there was always a better option to the one assumed by the Minister of Finance. And that is the case of pharmaceuticals, and that where it is established that it is not open to challenge purely on that basis.
But are you saying this is a regulatory power and not a revenue-raising power that's being exercised by the Minister?
No, I'm not saying it's a regulatory power.
But then I don't understand what the
Perhaps
relevance of
I
pharmaceuticals.
don't understand the question if I could restate.
So, my understanding of casino association in those cases is that there's a distinction drawn by the Constitutional Court between regulatory and
Yes.
revenue raising.
Yes.
Regulatory processes and revenue raising processes. If I'm to understand you, this is simply a regulatory process, 7.4. It's not revenue raising.
Well, this would be raising revenue of what, 13 billion.
Yes, that's quite
For the
right.
state, yes.
So if it is raising revenue, then how does it fall? How does it then fall squarely within the terrain of the minister and not subject to parliamentary approval?
Because it is not determining whether to raise revenue by imposition of VAT. It raises revenue by increasing the rate of VAT.
So you're saying the increase of the rate of that is the exercise of a regulatory power as opposed to the exercise of a revenue raising, it's not a revenue raising exercise.
In the context of exercise of regulatory power, I think in the context of Shuttleworth, I wouldn't say that because it does not seek to correct any misconduct. It is very clear that it intends to increase the revenue that the state...
So is it not the exercise of a revenue raising power then?
I don't know if it's an exercise of a revenue raising power because the exercise of that power is already in section 7.1, it is done. It is a question of adjusting the rate, and that is the distinction between 7.4, 7.1, rate 7.1.
So let me understand what your adjusting the rate in your mind is what? What is it, what kind of exercise of what sort of power?
I would think that it is a delegated power
To raise revenue.
to increase the rate of revenue.
So how can that happen when this Constitutional Court has been quite clear that that may not happen?
Because in casino association, the court had an issue that the minister, the act provided for, rates to be paid, and the minister was to determine that rate. And that was the end of the debate. And in that sense, then the minister is the one who determines the rate with no reference to the legislature.
But in this case, the minister has determined the rate subject hinged to the annual budget, tethered was the word we used earlier, which is prepared by the minister.
Yes?
And it's not subject to parliamentary oversight,
It is.
but only subsequently.
Section
on your
7.4 says as much. It is subject to
But
parliamentary oversight.
As I understand you, only subsequently.
It can only be subsequent because unless it is placed before Parliament, there is nothing for Parliament
So
to
what is the
confer.
purpose of 8.4?
8.4 is to give the Parliament opportunity to go through its processes via portfolio committees to debate that fiscal framework, which incorporates this
And then
adjustment.
what is the effect of the resolution of Parliament?
After
After
it has debated.
after it's gone through the committees and the report's been taken to Parliament, what is the effect of that
And it is to
resolution?
adopt the money bill presented before Parliament.
But that wasn't what occurred in this situation on the 2nd of April. What was the resolution that was taken?
Well, what occurred on the 2nd of April, we pointed out in a document that is a matter that we will leave to Parliament, and we accept that it may have its challenges, and I'm not saying yes it did or it did not. I point out specifically with reference to section 8 sub 6 that the fiscal framework is presented, it goes to portfolio committee, they make their recommendations, the minister comments thereon, and it goes to Parliament for final decision. Now, Parliament may make a decision inconsistent with the recommendations made by the portfolio committee. It's open to it.
The notion of no taxation without representation seems to be a sort of vague concept in the mind of the minister. I mean, you seem to put aside parliamentary processes and say, well, you can come back within 12 months and tell me I'm wrong.
I don't put them aside, my lady. I accept that because of the speed required to address the issue, our constitution permits a provision such as Section 7.4 to allow the minister to make the necessary adjustments subject to parliamentary oversight.
I think we've seen in the world the dangers posed by executive creep, with executive orders made not tethered to the constitution always.
But this one is precisely because certification tells us that that separation is not absolute, it is permissible. It has to satisfy certain factors in order for it to be allowed, chief amongst which is to locate within the impugned section whether parliamentary oversight is retained.
So if I could just understand you, Mohlaba doesn't apply, Casino Association doesn't apply, Shuttleworth is also distinguishable on the minister's argument. All those decisions of the Constitutional Court are distinguishable.
Let me start with Mohlaba for the moment. The court will recall that in Mohlaba, the impugned section gave the power to impose that tax or levy, what it was, to the traditional council with the concurrence of the premier. And it ended there. And Mohlaba did point out that that's a plenary function and only a legislature may do so. So on its own terms, Mohlaba would never have survived. And I say that Mohlaba does not have the necessary parliamentary oversight implicit in that impugned section. And that was the basis on which it was held to be unconstitutional.
Do you still have a long argument to present? Because you probably have about 5 minutes if I look at when we started.
I have about 5 minutes.
But I understand that we've engaged you quite a lot.
Thank
so,
you.
Yes.
And when we say the Casino Association also had that problem.
That there's no parliamentary oversight.
That there's no parliamentary oversight. It's the absence of parliamentary oversight within the impugned section itself that will render it ipso facto unconstitutional.
So is there any case that does apply?
To New Africa. New Africa would apply. And I think the exposition set out by Justices Rogers and Polapen is of assistance in this regard, where they listed the sections in various acts that have the same provision. And all of them, what they have in common is that they retain parliamentary oversight.
But was that premise accepted by the majority?
It was not resorted to by the majority, if I understood the judgment correctly, my lady.
So they adopted a different reasoning to that of the minority.
I was saying what is set out by Justices Polapen and Rogers is persuasive and explains this oddity that I am trying to argue, and the basis on which I distinguish Section 7.4 from Mohlaba, from Casino, and from Smith. If one has regard to those sections listed in the, and this starts at paragraph 173 of the judgment, and involves the Customs Act, the VAT Act, and the like. It's a categorization of the various types of sections that would permit for an act by an executive in circumstances where the parliamentary oversight is maintained. In this regard, they point out that New Africa's argument at the time rested clinically on the approach to the separation of powers, and that the delegation of lawmaking power, which is too absolute for efficient governance in a modern state.
But didn't the majority in paragraph 105 of the New Africa Judgment put paid to that notion as it was developed by Rogers and Colopin J, where it says that in determining whether a charge is a tax, one has to find the dominant purpose of the legislation. And it goes further. The seminal test is whether the primary or dominant purpose of a statute is to raise revenue or to regulate conduct. And what they've decided here in New Africa, it regulated conduct.
In that instance?
Yes.
Yes. And it's because if we look at Shuttleworth, that is where that distinction was drawn.
But what is the importance of that distinction? The importance is that if it raises taxes, it falls in exclusive domain of the legislator.
Did it impose taxes in the contract? Did it impose taxes?
Well, imposed.
Because in Shuttleworth, it was held that it was not imposing a tax.
And here the minister imposed tax by raising.
Section 7(1) imposes the tax. The minister adjusted the rate at which.
But the adjustment is revenue raising. It's not regulatory.
No, it's not regulatory. That much I concede.
So you concede
So
then it's distinguishable from New Africa, which was regulatory. It was responsive to the conduct of diplomats who were abusing the duty-free entitlements that they have.
I do, and hence my reference to the minority judgment and the base and.
So there's not a clear judgment of the Constitutional Court that's on all fours with your argument.
For now, there is, in my lady, because all the cases that have come to the Constitutional Court, Matroba, Casino Association, Smith, they all had the flaw in that they did not provide for parliamentary oversight. In Shuttleworth, it was held that it was not an imposition of tax.
What I find interesting from the minister's perspective is that this imposition of a higher tax rate in respect to VAT has national significance and particular significance to the poor. And that's the reason that the EFF has invoked the various provisions in the Bill of Rights. And in those circumstances, it seems somewhat unusual to rely on New Africa, which was really a case responsive to a particular conduct by a small class of people, when in fact this has national significance to almost every person living in the country.
Yes, I would like to place on record that the potential impact this will have on the poor is not lost on the Minister of Finance. If her ladyship recalls.
But then why is the minister so adamant to raise or impose the levy or raise VAT when the commission is of the view that there might be other different avenues to fill the gap of the revenue?
There might be other avenues. It's a question of their availability and immediacy to address the deficit.
Did the minister say availability or the extent to which they will dent the deficit, if I were to use that word? Is it a matter of availability, or the minister seeing that as not really being as significant enough to be able to meet the deficit?
No, well, on the basis of what SABC is talking about, it can be said to be significant, because what SABC suggests can potentially be raised is significant. The question is, it requires capacitation of SABC and providing resources. Exactly when that money will begin to flow in to address the deficit is not an issue that is before us.
Okay.
The Minister of Finance has dealt with other options, including raising national debt.
Okay, I think we're gonna have to stop you at 3 o'clock. I know that we've engaged you, and at least, but I think you should wrap at least at 3 o'clock,
Okay,
so that we can give Parliament their chance.
On the question of to her ladyship's question about the national impact, there is a potential impact that borrowings would have, and these are factors that the Minister of Finance has considered in making the choice that he did, and these are articulated in the answering affidavit. It cannot be accepted that the raising of borrowings against the 3 billion debt standing is not going to have any impact. The other side of the coin is the impact, unfortunately, on the same class of people if that deficit is not met, because there would not be sufficient funds to meet the social programs that government is responsible for, including health, including school, including paying grants. And that is the way that the minister must undertake. So it is not like the minister is oblivious to the impact of the VAT, the 0.5 adjustment. At the same time, he is not oblivious to the failure to raise revenue in the interim to meet the social programs that the very poor, unfortunately, depend on. Some members of society depend on private medical aid and the like. The poor, unfortunately, rely on the very public hospitals, which the Minister of Finance must make provision for. The question I just need to quickly turn to is whether or not the applicant has made out a case for the suspension, whether it's interim relief or whether it's an interdict or whether it is suspension. We submit based on the way it is pleaded. It amounts to the same. I would, in this regard, refer the court to by the applicant, I mean the DA, because we know that the EFF is not seeking to interdict the minister's decision. These matters are pleaded at paragraphs 116 to 118. The most important being the right of the public not to be taxed without representation. And that is the fact that the introduction of 0.5% at the time of introduction had not been adopted by Parliament. And as we have argued, in the context of the nature of our constitutional scheme, that is permissible as long as Parliament retains oversight and can address that adjustment, whether to adopt it or to reject it, in which event it ceases to apply. The second is the question of prospect of success in the constitutional challenge, and we sought to demonstrate that based on the cases pleaded and the cases involved in support thereof, Mutlaba and the like, that challenge is unlikely to succeed.
The debate that the bench has had with you and the problems highlighted, the debate that the bench has had with you and the problems highlighted, don't they really illustrate that perhaps there are prospects of success that need to be dealt with at the later stage in Part B? Doesn't that at least show that?
I wouldn't, unfortunately, say so. I would say it may create a debatable case in Part B. Not that Part B will necessarily succeed. And we have...
But our function is not to determine whether it's going to succeed. Our function is just to determine whether it's a prospect of success.
Prospect of success in the relief that it seeks in Part B.
Yes.
Yes, so, and that's what I call succeeding. So if there are prospects of success that the relief they seek in Part B would potentially succeed, then I do accept that that's what the court takes into consideration.
Yeah, in light of the potential incongruence between the parliamentary process and 7.4, in light of the fact that you say there is no particular case that meets your case necessarily, or your defense necessarily, isn't that an illustration that there has to be some canvassing of this issue in Part B?
There's only one case, except it's not the Constitutional Court, that I would say is more or less on fours with our case, and that's the case of this court in Pioneer Foods. I just mentioned it. I'm trying to find the correct citation. It's across the paper. There are two of them. The first was also for interim relief, and the second was Part B. It's Pioneer Foods versus Minister of Finance, 2019 1 SA 273, Western Cape, and that was a judgment of September 2017. The second is second is also Pioneer Foods versus Minister of Finance, and the citation there is 2018 for all SA, page 428, and once again it's a judgment of this court. Those judgments were confronted with similar issues.
On prospects of success.
No, just generally on what the court was dealing with, the exercise of the power by the minister within a context of an abuse action. And structured more, in large part, similar to what we have here, where the first was an interim interdict and the second was dealing with the constitutionality of the section in Part B. So I'm saying that if we accept the constitutional structure that we have and the notion of partial separation and the fact that it is permissible for the legislature to delegate a power, such as happened in this case, to the executive, subject to maintaining parliamentary control, then that would not be unconstitutional. The converse, of course, applies. If the court were to find that it will always be unconstitutional, then that would be paid to that argument. Lastly, I would just like to point out the principle set out in outer regarding the restraining the exercise of the executive power, which for now falls within the exclusive terrain of the executive, and invite the court, as the constitutional court did in outer, to carefully assess how and to what extent the relief sought will disrupt the executive. The disruption in this subject would be, firstly, the entire fiscal framework would have to be returned to the Minister of Finance to consider another means of addressing the deficit that exists in the budget. The means that eventually he could determine are applicable, and I'm not saying necessarily they are, could very well have more adverse consequences and impact on the country than the introduction of the 0.5%. Secondly, it would significantly delay the parliamentary budget adoption process, which means at the start of the 1st of April, technically, the government would be without an approved budget and would not be able to fund its obligations.
But Ms. Saylor, Parliament can rectify all of that. If the money bill has been introduced, Parliament can consider it. Because if Parliament consider there must be a 0.5 VAT rate imposed over and above the 15, which means 15.5, that's the end of the story, that's the end of the matter.
And our submission is that the bill is before Parliament.
Yes, but if, and in the interim, what's going to happen in the interim?
Or within the context of his lordship suggesting that it's not necessary for the power in 7.4 because it can be done through the introduction of a money bill. Unless I misunderstood it.
What I'm saying is in the power of Parliament to decide and to impose taxes. If Parliament decides by majority votes that the 15.5 VAT increased from the 1st of May and then thereafter another 0.5% to make it 16% in 2026. If Parliament decided, that's the end of the matter.
That's correct.
But Parliament must decide it. It's not up for the Minister to do that.
We are suggesting that the Minister is empowered to do so in the interim while Parliament runs it through its process to confirm and compare, actually the section compels Parliament to do so, to confirm or reject and overturn that adjustment. And that is in law permissible, based on the cases that we have cited, and that it is not unconstitutional to do so.
Okay, thank you. On the issue of costs, as well as there's one point besides costs. Whilst you're thinking about costs as well, paragraph 5 of the EFF's relief is broad enough, I think, to include all respondents, because it wants to interdict the giving effect, including the introduction of the 0.5 percentage points pending finalization of Part B. Doesn't that implicate the powers of the minister?
Well, our understanding of 5 was the EFF sought to interdict the giving effect of the imputed report in the fiscal framework, and that is all they seek.
Or taking any steps in relation thereto?
And taking any steps in relation to that fiscal framework.
Okay.
And the point that we make is that even if it succeeds in that regard, the power exercised by the minister in terms of 7.4 remains unaffected.
Okay. And the costs?
On the question of cost, my lady, we ask for costs because it is clear, it must be clear from these papers that technically what the DA sought to do is to achieve through judicial intervention what it could not politically. We have pleaded at paragraph 30 of our answering affidavit. It's part of a bigger subject, which is the budget process. That demonstrates continuous engagement with all cabinet members, and these are members of the GNU, that takes place in cabinet. That is not denied by the DA, so it must be accepted that that process was fully followed.
But what of their reference to the 2014 decision of Rogers J in this court, in which it was said that you must look at the character of the litigation?
I understand that, except that my point would be the character of the litigation cannot detract from an attempt by a litigant to use court processes to draw the courts into arenas that are political in nature. If the DA accepts that there was full engagement with the political parties in the GNU that eventually adopted through cabinet the budget, it cannot seek court's help to extricate itself from there. In the founding affidavit, the DA indicates that it had 3 weeks of engagements with the rest of the government to try and address this VAT issue, and they were unsuccessful. Consequently, accepting that it could not overturn that increase through those means, we submit that the DA can resort to the courts.
So you're suggesting the litigation is frivolous and vexatious?
We are suggesting that the litigation is an abuse of court process.
Thank you.
Thank you.
No, I've got nothing.
Okay, thank you, Ms. Selo. Okay, anything else?
No.
I thought you were whispering.
It sounds like there was a bit of confusion about our heads of argument. I just wanted to check that the court didn't receive.
Yes, we did.
Thank you, madam.
Thank you very much. Ms. Pillay.
Thank you, madam.
Thank you. It's now 3:05, so you have until 4:05.
Thank you very much. I'm indebted to the court. Members of the court, there are 4 issues I intend canvassing in our argument. The first is the process that is adopted by the finance committees, and as we understand it, that's one of the legs of challenge. The second is whether the report that was ultimately accepted met with the prescribed threshold in Section 8.4 of the Money Bills Act. The third is to deal with the allegations of substantive irrationality/deceit as a basis on which to set aside the decisions. And the fourth is to deal with the question of remedy in some circumstances. Members of the court, let me ask that the court go to Parliament's answering affidavits. It's 05, and can I have the claimants of 0560?
Oh, 516.
0560. And there, Parliament sets out in some detail the process that is followed in the adoption of the Finance Committee reports. I'm going to spend a few moments, Justices, going through that process, and I do so in order to meet the challenge of the so-called procedural provisions. As the court will be aware, it's common cause that there was a joint meeting on on the 1st of April by both the Select Committee and the Standing Committee. The court will also be aware that there was a draft bill, a draft report, what we refer to as version 1, that was presented at that meeting, and that draft report appears in the DA's affidavit as 10.1. It's 02-99, and that's 10.1. The court will also be aware of the explanation given by Parliament that the members at that joint meeting at 37.3 went through each clause of the draft report, they deliberated on it, and they proposed amendments to it. And it's common cause that those written amendments were not effected at that joint meeting. The court will also be aware that the DA, EFF, and MK proposed or tabled specific alternative proposals. And the court is aware that Action SA tabled a very specific proposal. And can I have the court have careful regard to 37.6 of Parliament's answering note. It says there that Action SA tabled the proposal for the draft report, which included the fiscal framework and revenue proposals, to be accepted with recommendations to the Minister. The proposal was moved by Gansey, it was agreed to, and seconded and agreed to by the majority.
Was it not slightly different, Ms. Gillette? Sorry, I'm interrupting you in your 10 minutes.
No, not at all.
It was that Action SA expressed it stated expressly that it was against a VAT and tax increase, and that it would support the report subject to the strict condition that.
And I'm going to take your ladyship through to the report as to where that's reflected. But for the moment, I'm going to ask the court to have regard to 10.1 being the initial report that was tabled, and 7.2 and 8.2 to Parliament's affidavit being the final reports as tabled. And I'm going to come back to that in a moment, Justice Savage. And then, if the court is to listen carefully to the video recording, the YouTube recording of this, which the court will do in course, the chairperson specifically sought clarity from Mr. Beasley as to whether Action SA was moving for the adoption of the report with those recommendations. And Parliament says a viewing of the footage shows that this was confirmed by Mr. Beasley, and the timestamp is given. Then, members of the court, you have been taken to the issue of the voting in relation to that report. And if I can ask the court to then have regard to the way in which the proposed amendments occurred. In relation to the Standing Committee, that's dealt with at paragraph 38 of Parliament's affidavit, where members were requested to send their proposed amendments on version 1 to Parliament's support team, and the DA, EFF, and Action SA sent their proposals by WhatsApp, MK sent it by email. So there's a written record of what those amendments were. Parliament then quotes them at paragraphs 39 through to 42 of its affidavit. And then Parliament explains that those were then sent through, and at paragraph 43 of Parliament's affidavit, those were then sent through to the chairperson and the process that then followed. Parliament explains quite specifically that at 45, that there was a version of the report that had been published, it's version 2, which is attached as AA5 to Parliament's affidavit. Following that publication, Mr. Wickham sent this report as published to members of the Standing Committee, and Action SA raised a concern about it. Parliament says at paragraph 47, it effected Action SA's proposed amendments, and it then goes on at paragraph 48 to speak to where in the report they were. And then if the court can have regard to, I think before I come to the final thing, if I can ask the court to have regard to 0531 at paragraph 80, where Parliament says the DA, NKP and EFF rejected the report. The following parties voted in favour of it: ANC, Action SA and IFP, and as a result, the report was adopted by the requisite 6 members to carry it through. That was the majority. And then, if I can, apologies for doing this, but if I can ask the court to turn back to 05-24, and that's where the final report concludes by saying, having considered the fiscal framework and revenue proposals, the Standing Committee on Finance accepts the fiscal framework and revenue proposals. The DA, NKP and EFF reject the report. And then the process, members of the court, is also explained in relation to the Select Committee. That starts at 0525. And the result appears in paragraph 63, where it says that the proposal as reflected by the Select Committee or the resolution is then quoted there. Having considered the report of the fiscal framework and revenue proposals, the Select Committee accepts the fiscal framework and revenue proposals. The 3 parties proposed amendments to the fiscal framework. And I know there's a quibble about
your 10 minutes is up, Ms. Pillay.
whether there was a rejection by 3 parties or whether there were amendments to it. I'm going to have the court just have regard to those proposals as put up by the different parties. They appear at paragraph 39 and following of Parliament's answer. So, if I can then tie that up by asking the court to go to AA 2.2, which is at 0583, which is the agenda to that meeting. And the agenda made it clear that it was a consideration and adoption of the committee report on the fiscal framework and revenue proposals. The court will then have regard to the draft minutes that appear at AA 3.1 and AA 3.2. That's at 05-84. And the court will see there that at 05-85, last paragraph, after deliberating on the report, these parties proposed amendments. However, the proposals were not agreed to by the majority of the committee. And the court will see over the page the report was duly adopted by the majority of the committee to accept the fiscal framework and revenue proposals. And so if one looks or listens to the 8.5-hour record of that meeting, there are parts that are difficult to understand, there are parts that are difficult to follow. But the following is clear. The report was put to the meeting, it went through, members of the meeting went through that report clause by clause, and there was ultimately a vote in relation to the adoption of that report. That vote was carried by the majority of members.
What was voted on, Ms. Pillay?
The adoption of the report.
Which report?
And it was so Madeleine, that's perhaps let me go there. So your ladyship is aware that the version 1 was presented.
Yes.
Your ladyship is aware that they were that report, the committee went through that report on a clause-by-clause basis.
Yes.
And amendments were put to that report. There's a track version of it somewhere in the papers that your ladyship has.
Yes.
And those amendments were not reduced to writing in that meeting, because as Parliament explained, someone was sitting there and taking notes. After the meeting, the amendments were effected. But what was put to the vote was the report as amended through the verbal discussions that we had.
Where does it say that? Because it seems that what's put is the adoption of the report, and the report that's before the committee is a draft report, which is then subsequently amended.
Yes, if I can just, if your ladyship will bear with me for a moment. At 37.6, my lady, where Parliament talks about the proposal by Action SA, and I just quoted whether Action SA was moving for the adoption of the report with those recommendations.
So is that now version 1 or version 2?
It was version 1 with the recommendations as presented during the oral engagement at that meeting.
And the other recommendations that were made?
With the recommendations. And I'm going to take the board to it because there's no, this is an important point, there's no debate that the report, let me have the report go there, it's AA 7.2. And it appears at 05355. I'm going to ask the board to go in particular to section, to paragraph 6.26 and following. It's at 05-364. The SARS and revenue
So
proposal.
it's 05?
05-364. At 6.20, so under the heading in SARS and revenue proposals, there's a discussion in relation to the tax gap. And apologies, if I can just take it a step back there. The court will have regard to the heading, which appears at 05-360, which says committee's observations and recommendations. And then it goes on to deal with the economic performance and outlook. And then just above the heading, just above 6.8, there's a heading that says fiscal framework. And then just above 6.26, it's the SARS and revenue proposals. And if the court would
Sorry,
have
6.20?
above 6.26 is the heading that says SARS and revenue proposals.
Yes.
And then if the court has regard to what's said at 6.28, the committee notes the proposal to increase the VAT rate by 0.5 percentage points in 25 and 26, which will take the VAT to 16%. And then the committee further notes the following. And if I can, then, Justice Savage, to your point, draw the court's attention to exactly what's said at 6.32. That's the Action SA's proposal. The fiscal framework tabled by the Minister of Finance is supported, subject to the strict condition that National Treasury facilitates receipt of substitute revenue proposals from the committee. And then it goes on. Furthermore, at 6.33, that's also part of Action SA's proposal.
But where is it recorded that Action SA stands against the VAT and tax increases? That's at 7:30:04 of the record that was sent to us over the lunch break.
If your ladyship will bear with me, I'll get to it in a moment. I'm going to,
Because what we've got here is not being recorded.
I'm sorry.
What Action SA said was not recorded here.
Madam, all I can say is that the Parliament's given the explanation as to how Action SA's proposal came to be recorded in the report. And there was an earlier version of it, which there was some difficulty with, and this was the final version of it. So there's no...
But does this properly reflect what is approved? Because it expressly states at the meeting, we stand opposed to the VAT and tax increases, and then that they would approve the report subject to strict condition that's then set out at 6, as is set out at 632.
Yes.
That's the basis on which they'd accept that.
Yes.
Is it not important to reflect that they expressly stand against the VAT and tax increases? Because the implication of the strict condition seems to be that they are labouring under the misconception that what is going to occur is that over a 30-day period there's going to be a debate about what the appropriate way forward would be. And that point is raised, in fact, by various, as I can see it, various of the members, the EFF member of the committee, the NK party member of the committee, and so on, that these issues are not properly recorded and we're not sure what we are approving. None of this is recorded in their report.
Yes. Madam, Sarah was saying that Action SA specifically approved its proposal as captured in the report. I can't take that any further. Had it been of such a nature, and what's also of significance, the court will note from the papers that Action SA's initial proposal was to move for an amendment of the fiscal framework. Action SA later shifted from that proposal.
And what was that proposal?
I'm sorry?
What was that proposal?
What was that?
Yeah, from Action SA, ultimately.
So it was initially an amendment to the fiscal framework. It shifted from there to accepting the report as it is, subject to the inclusion of its recommendation.
And what was its recommendation?
As reflected in the report, Madam.
Well, that's not what Action SA said.
Madam, with great respect, that's what Action SA in the process as to how these reports were finalised. I've taken the court through to it.
I think my brother is referring to the recording, that what was in the recording was not stated in writing, or rather what is in writing is not a reflection of what happened at the meeting itself.
My lady, I don't...
And this is under your heading of at 05360 Committee Observations and Recommendations.
Yes, that is. But my lady, I refer to what's been said at 37.6, my lord, sorry, at 0517. I've taken the court there already. And the fact that at paragraph 38, where Parliament says in terms, the DA, EFF, and Action SA sent their proposals to the Parliamentary support team on WhatsApp, and this was the proposal as reflected.
But is that not a proposal in the context of an opposition, an unequivocal opposition to the VAT hike?
My lady, I've pondered this long and hard because I see the counter-argument. The counter-argument would be, well, how can it be said that the fiscal framework is to be accepted in light of the alternative proposal that Action SA made? And I can't take it any further than to say this. On the sequence of things, the initial proposal was a dead right amendment to the fiscal framework from Action SA. There's a shift from there to an adoption of the report with a recommendation. Now, I know friends make a lot about the question of the recommendation, and we're going to come to it in a moment, but it's really all parties saw it as a non-binding recommendation.
But now, its adoption seems to reflect the expressions that were made by the committee of non-acceptance of the increase. Because if you look at the report and read it, you'll see it's not just the noting, although it says we note, but the expressions that are there are very strongly much against. And that's why, at the end of the day, there's an adoption of that recommendation to reflect the discomfort of the committee with that. So can those things be together? Can you accept, but at the same time say, go and think about it further and then come back to us in 30 days' time?
Yes, yes. So, Malene, I see it in the following way. There was an acceptance of it. There was an alternative recommendation that was put on the table by actually saying, clearly, I don't want to trample on the minister's approach to any of this, but clearly that recommendation was there. It could have yielded one of two outcomes. It could have yielded an outright rejection of what had been adopted in relation to the VAT hike, in which event a different process would have commenced. Or it could have yielded no alternative to the VAT hike as proposed.
So it was in between. So is it not ambiguous? Because it's in between accepting and rejecting. So it took the midstream of saying, okay, go think about it and come back in 30 days. So isn't that ambiguous?
I submit not, because I submit that had there been an alternative that came up in those 30 days, then of course one would have had to rolled back the clock around it, and one simply couldn't carry on with this. Other than, or instead of there being, if there wasn't an alternative, then it would have been this fiscal framework as adopted that would have carried the day. And I submit with great respect, Malene, much of it turns on how the parties themselves actually understood this. If the court would bear with me for a moment. So we've made the submission that by virtue of having adopted the report, these committees adopted the fiscal framework.
Can I just ask a further question? When the section says there must be a clear statement, does it mean one line that should be read that we accept? Or does it mean you read the report as a whole and that must constitute the statement, or that must support the conclusion or that statement that's made?
Yes. So, Malene, there goes a very difficult question. I'm going to come to that in respect. I think it straddles, as your ladyship points out, perhaps at two lines. The first is whether or not it met the defining threshold under 8.4 for a clear statement, and the second is whether or not it resulted in a substantive irrationality of the outcome. And I would submit whether or not, on the first point, whether it met the threshold under 8.4, I would submit that one has to look at the report, obviously, overall. And what certainly on my reading of that report, it reflects that there were concerns raised in relation to the VAT hike. There's no two ways about it, there were concerns. But overall, the way in which it was managed was with a recommendation that came from Action SA to look at alternatives. If no alternatives carried the day, then the fiscal framework as it was the fiscal framework.
But there was no intention to even look at those recommendations. I mean, the Speaker was alerted of the problems, the committee secretary was alerted of the problems the same day, the EFF sent a letter to the Speaker the same day, the DA the next day, to say, look, we've got problems with this report, and it was pushed through to Parliament. There was no intention to engage with the 30 days. So at least on the face of it, it appears that Action SA naively thought that its strict condition was going to get even the most basic time of day. It was never anybody's intention. The purpose, which was simply to force it through. And if you look at the record, the minister, the chairperson of the, when Mr. Molefe says at 7:47, what are we adopting? Because the report has changed so many times and we haven't seen the report. The chair says, let's proceed. And he wants an adoption. Then when the letters, the same day when the political parties contact the secretary of the committees and say this doesn't reflect what we discussed, The letters are then sent to the Speaker. It's literally pushed through. And what's quite extraordinary is that it didn't have to be. You could have, if the process, the Speaker, your client, could have slowed the whole process down and said, let's make sure we're all on board. We've got a report. This is an issue of national importance to every single person in the country. Let's make sure we're not seen as pushing this through with undue haste, and that we've dealt with all of the concerns that have been raised. But that was not the approach taken. In fact, it was the contrary approach. And one has to ask why. Why is there such a reluctance to engage either with the strict condition or to have the Minister consider other options? Why is this no taxation without representation consideration just given short shrift?
Malali, I can't say anything beyond the fact that the Action SA proposal, as it was sent to Parliament, is what was incorporated into it. If the court is to find ultimately the report read as a whole doesn't meet the clear statement envisaged by 8.4 of the Mining Laws Act, then I have to accept that that's the end of it in relation to that report.
I think my sister raised an important issue also that if not all members are on board, meaning not everyone understands what is being voted on at that point, and then it simply is adopted, does that not taint the process?
Yes. So, Mariam, that's a particularly difficult issue in relation to politics. And I say that cautiously because if the court is to listen to that record, it's clearly a large part of it is around political posturing. And it does raise the question as to what is the appropriate threshold, the appropriate point at which a chairperson can say, I've formulated the correct question, I've asked it, I've put it to vote. The committee has spoken, and I'm carrying that. And
Well,
I would submit, and certainly...
Ms. Pillay, that is one way of looking at it. There's also another way. In particular, if you have regard to all the questions that have been asked by the MKP, Mr. Brian Molefe, Mr. Burke, then it's Mr. Van Rooyen of the MKP again, then Mr. Molefe again. The timestamp here that I've got in the record is 0947, paragraph 114.12. Mr. Molefe said that Mr. Beasley had stated as part of his motion that Action SA did not support VAT and asked whether that was part of what we have just adopted. So there was massive confusion. But why did the chair, as my learned sister has indicated, so adamant and eager to adopt this? For what possible reason?
Justices, I can't take it beyond referring the court to what I've said already. I'm not going to go there. The question was pertinently put to the committee as to what was being voted on, and there's a vote to that Parliament. And Justice McCarthy, one might say, on having looked at, well, there was a fair degree of uncertainty, unhappiness, or whatever it is. But it comes down to the question of what was the question that the chairperson put to the committee, and what was the process around that? On an 8.5-hour long meeting, what happened in hour 4, what happened in hour 5 when it's overtaken by something at a later stage, I submit with great respect ought not to carry today.
Do you accept, Ms. Pillay, that the report that was put before the committee and was voted on is not the report that was then placed before Parliament?
No, perhaps I'm not being clear, Justice.
No, you are making it. It's a physical report that was put before the committee.
Yes, but if this physical report had been overtaken by the amendments that occurred in that report.
So, you're saying the report plus amendments was being voted on, although there's no reference to any more than the report is adopted.
Yes.
So the physical report that was before the committee is not the same report that was placed before Parliament the following day.
Yes, because I've explained to the court what the process was in relation to that. So if you could bear with me for a moment.
But is that not a problem, that you've got a physical report voted on, which was placed before members of the committee, They weren't recalled to consider an amended report and to then vote on the amended report to determine whether they accept or want to seek further amendments in terms of 8.4 to the amended report. But rather, the first report that was placed before them is a vote is forced on that report. That report then has to be amended, because it's not in the form that it was placed before the committee is capable of being put to Parliament, because it doesn't achieve the purpose that 8.4 requires. So even if it was approved, the approved report doesn't meet the requirements of 8.4.
So there are a couple of questions your ladyship's put to me there. Let me take it in turn. Question one, as a matter of principle, is there anything objectionable about draft one of the report being put before committee, amendments being effected orally to that draft, and the amendments subsequently being reduced to writing and the written document being put to Parliament? And I would submit, with great respect to that process itself, there's nothing objectionable.
Is that not fact dependent though? I mean, one can't say as a matter of principle, of course, and I raised that, I think, with Mr. Nukatobi, yes, that certainly there'll be circumstances where an amendment post to votes might be agreed by everybody, and that's fine. But there'll be other factually where that is not supported.
But for the moment, let me just put it, and certainly on the facts of this matter, my submission is there's nothing objectionable about that as a process. And there's no procedural requirement, whether it's in the rules, whether it's anywhere else that our learned friends have pointed to, that hasn't been met by virtue of that process. It then appears to me, Justice Savage, the next question is the report as amended in writing, pursuant to that meeting, does that reflect an accurate amendment of what's actually occurred? And certainly insofar as the proposals by the three parties went, Parliament's explained the WhatsApp messages, the text messages attendant on which those amendments were effected. So my submission is that there can't be any serious challenge that the counter proposals that were put up by the other three parties don't reflect what they had intended for.
But Mr. Pillay, the amendment that was proposed by Mr. Beasley,
Yes.
from Action SA, that's not being reflected in the report properly.
Why does your lordship say that it's not reflected in the report?
Because if you have regard to what they proposed, if you go to paragraph 40 of, I think it's the Speaker's Varney papers.
Yes. The speaker's answering.
Answering now. Sorry, answering papers. At paragraph 40, it clearly states what Action SA is proposing.
Yes.
But that's not being reflected in the final report. That was before Parliament.
My Lord, if I can draw your attention to
More importantly, at I think it's timestamp 072958, Mr. Beasley clarified that Action SA stands against any VAT and tax increases.
Yes. And if the court is to look at that as against 05-366 and 367.
Zero 5-3
66 at 6.32 and 6.33.
Yes.
And that's where it's been amended to be incorporated. And the court will also have...
Sorry, where do you say it's incorporated?
6.32, subject to the fiscal framework tabled by the Minister of Finance, is supported subject to the strict condition that National Treasury facilitates the receipt of substitute revenue proposals from the committee, together with corresponding expenditure savings that will form the basis of an alternative revenue proposal instead. And then it goes on. So that is the Action SA proposal.
What was the meaning of that amendment? I mean, what does the meaning of that supported subject to strict condition? What is your understanding of the meaning of that? I mean, it was not an amendment to the report. It was just a point of interest.
Sorry, Justice Savage, perhaps there again, the conflation, and I accept because of the way in which this panned out, but there was the report which was amended. The imperative for the committee was an adoption of the fiscal framework, an acceptance of the fiscal framework, or an amendment to the fiscal framework. And we've taken the court through in our heads of argument as to the sections in section 6 of that report where the summaries around the fiscal framework has been provided. And certainly on my reading or listening to that recording, I certainly don't come to a conclusion that the substance of what Action SA proposed was an amendment to that report. And
so what is it then?
It was a recommendation. And it was a shift in Action SA's stance, and it was, and perhaps I can do it this way, Justice Savage. If I can ask the court to look at our heads of argument. And perhaps my learned friend Dr. points out to me, the EFF's papers, I'm going to ask the court to go there, it's at 07-15. Perhaps it might be helpful to start the page before, 07-14, where the EFF says, Action says Alan Beasley proposed an amendment.
Which paragraph?
31, sorry, my lady. Alan Beasley proposed an amendment to the fiscal framework, which he also texted or caused to be texted to the finance committees, including myself. The recommendation was that the fiscal framework by the minister is amended and it recognized, etc. in the time. And the court will look at that initial proposal as made by Action SA and contrast it to the proposal that it ultimately submitted. And I'm going to then ask the court to look at our heads of argument.
So if I understand you, Action SA moved from seeking an amendment to granting approval subject to a strict condition, under the mistaken belief, somewhat naively perhaps, that this 30-day engagement period was going to ensue, when there was no intention to engage in that 30-day period, because the following day the report was placed before Parliament.
So, my lady, I'm unable to account for how Action SA understood it, and I'm unable to account for whether there was an intention to comply with it. I have wondered about what the consequence would be if subsequent to the 2nd of April, that engagement process took place and yielded an alternative process, an alternative outcome to the 0.5% increase. And it seems to me that had that happened, then it would have been the subsection 6 amendment of the fiscal framework that would perhaps have had to go all the way back on it.
Is the use of report and fiscal framework synonymous for the purposes of your argument? Now, if that is the case, if the report is adopted with the amendments, would that not amount to an amendment of a fiscal framework?
Not at all. There's sections, my lady, in our heads of argument we've drawn it out, where the sections of the report speak directly to the fiscal framework. And there are other parts where it speaks to the public consultation process, the input from National Treasury, etc. But the submission is an amendment to a report doesn't result in an amendment to the fiscal framework necessarily.
So the adoption may not necessarily be the same. So the adoption of a report may not necessarily be the adoption of the fiscal framework.
Yes, but the submission we've made, Parliament's made in this, is that given the content of the report and the sections dealing with the fiscal framework, the adoption of the report amounted to an adoption of the fiscal framework. And your ladyship will see that's certainly how the DA understood it. If the court is to have regard to the DA's own proposal, which I've taken the court to in Parliament's answering affidavit, it spoke quite pointedly to the fiscal framework needing to be.
Did the members vote on that statement to say that we agree to this statement, we agree to the amendment? So a certain part of the House says, or the committee says, we agree to the statement, we accept it. The other part says, no, we don't. Was there ever a point where that was done?
No, there wasn't, Judge President. So the way in which it actually worked was that it was the report with amendments that was put.
So it was assumed that, well, we've sent the amendments out, and that should mean that it's an acceptance of fiscal framework because only these three parties gave us the amendments.
Not at all, Judge President. At the actual meeting, in the last hour of the meeting, in particular, each of the parties, and with great irritation, read out their proposals word for word at the meeting. And attendant on that, the amendment as proposed by Action SA was supported, seconded, voted on, and it was then carried.
So each party says we accept, when they read their proposal, accepted three.
There was a vote that was, so the chairperson then put it to the vote and said, I now, and he specifically asks Mr. Beasley, do you accept the report with this recommendation? Mr. Beasley then affirms that that is in fact the case.
And everyone else?
I'm sorry?
And other people?
And that is then put to the vote, and 6 members, being the majority in the standing committee, then carry the vote on that.
But what do you make of the argument that was raised that the proposals or amendments were never shared with the committee members in written form?
So Justice Rapansi, again, we put the various timestamps in the affidavit, but the various amendments as proposed were read out, I don't think once, but twice in the course of that meeting. And so it's correct, there was no written record of what those counter proposals were that were being put forward, but they were certainly read out on my count more than once.
And the complaint that the question was never directly posed to the committees whether they accepted or amended the fiscal framework. Yes. What must we make of that?
Yes, so that is, so the way in which I see it, Justice Rapansi, it's like this. The agenda to that meeting made clear that it was the report that was to be adopted.
Excuse me, that?
The agenda to the meeting.
Yes.
And it was AA 2.2 to Parliament's affidavit. There was then the draft report, and there was then a vote on the draft report as inclusive of the amendments that occurred. So it's correct, there wasn't a written record of what those proposals were in the meeting. That happened after the meeting when parties were asked to send their written records.
But then how can the members apply their minds to the report and vote on it?
So, Justice Rapansi, there's a difficulty, and the question does reduce to this. Was it impermissible for those amendments to have been proposed orally and for the adoption of the report to have occurred attendant on those oral amendments? And my submission is there's nothing in the rules or anywhere else that requires otherwise, and therefore there's no unlawfulness certainly arising from that aspect of the process. Justices, perhaps just to make this this point, the DA itself recognizes that the recommendations made by Action SA did not have the effect of amending the fiscal framework. And if I can have the court have regard to our heads of argument at 12-32. And here says that the NA and NCOP met to resolve and adopt the fiscal framework. They say in terms, there's a very telling part which we've referred to in our heads, I can't find the reference here, but where Dr. Burke from the DA himself summarizes what the position was and what the import of Action SA's proposal was. And it certainly wasn't to amend the fiscal framework. If I can have the court have regard to paragraph 36.6 of our heads of argument. Where we say that the effect of Action SA stance is that it was accepting the report, which included the fiscal framework. Dr. Burke from the DA understood it as such, and we give the reference to the timestamp.
But what's to be made of the express statement that they don't oppose, they don't stand, or they in fact stand against the VAT increase?
So that comes to what's the import, and I don't want to play clever lawyer in Justice Savage, but I do want to raise with this point what then was the import of the recommendations that were made. And can I have the court go to 12-32 of our heads of argument, where the DA says there was this non-binding at 58.2, non-binding recommendation made by Action SA. The DA says itself at 58.3, that recommendation has no effect. It will not stop the VAT increase from coming into effect on 1 March.
But is it not a conditional adoption then? Is it not a conditional acceptance by the Action SA, at the very least, that this strict condition be complied with?
Well, part of the difficulty, Justice Savage, is what then is the consequence of that so-called conditional adoption?
Or can it be said that there's an acceptance?
And my submission is that provided, and again, I don't want to repeat myself, but provided there was the condition of alternatives being looked at, and that would either happen or it wouldn't happen, but the point was that Action SA specifically shifted from saying it wanted to amend the fiscal framework to saying it was accepting the fiscal framework subject to his proposal being carried.
But Ms. Pillay, you would accept that there was confusion at least?
I'm not sure there was, and Judge President, I think it's tempting to say there was when one listens to that recording, yes, and one takes piecemeal snippets out of the recording. But when one gets, and we've given the court the timestamp of where Action SA's proposal was framed by the chairperson, there was confirmation sought as to what its import was, and it was put to the vote. And I would submit that given that both the DA and the EFF understood it as such, the EFF's parts we referred to paragraph 60 of our heads of argument, where it too says that it was a non-binding recommendation. And so what this court perhaps is left with is this question: can it be that the non-binding recommendations as put up by Action SA have the effect that it doesn't have the effect of amending the fiscal framework?
But what if Action SA and all the rest of the parties that voted in favour of it was of the view that in fact it is binding?
Well, that's not the case that, with great respect, that the court has before it. The court has two parties challenging it, and both those parties proceed from the premise that it's nothing more than a non-binding recommendation. And who knows understands that there were different challenges to it on different bases, but the submission is on the basis of a non-binding recommendation. It cannot be said that in substance the effect was that it wasn't a clear statement of having.
But there must have been some confusion, because if one read the records and the conversation, it's quite clear that Mr. Beasley, who proposed the what recommendation, if I can put it that way, he himself says he's against the increase of that.
Yes.
I mean, so what must we make of that?
So my look, I expect that he does say he's against it.
Mm-hmm.
But of course, if he's against it to the extent that he didn't support the fiscal framework, then his initial proposal of having sought an amendment to the fiscal framework would have been the course to carry the day. And I accept, I've listened to that video recording many times, and there are many points at which parties say, well, we don't know what we're voting for, etc. And I submit with great respect that when the chairperson asked Mr. Beasley to confirm what it was, and he framed the question for the vote in the terms that he did, there could have been no confusion.
I'm not so sure. From where I'm sitting, I'm just saying I'm...
Your first.
Yeah. All right. Are you about to finish? I wanted to ask you a question on the relief sought, because in paragraph 9 of your heads, you say that the adoption of the report is neither a prerequisite nor a part of the minister's announcement to increase the VAT rate. The minister derives power to increase the VAT from section 7.4. Acting pursuant thereto, he made an announcement on 12 March, well before the parliamentary processes. In the circumstances, there is simply no basis that the order sought in relation to the Finance Committee. There's no basis for those orders, and that ought to be the end of the matter. That's what you say. The two questions is, what is the purpose of Section 8 processes if there is an unhinged power for the minister to go ahead?
Perhaps let me put it this way. It's a question I've grappled with long and hard. I don't purport to have a clear answer to it, but justices are reasoning it in this way. Can I ask the court to go to the Money Bills Act and section 7.1?
Section
7.1. And it says the minister must table the national annual budget in the National Assembly as set out in section 27 of the PFMA at the same time as the division of revenue and the appropriation. Now, the question then is, what standing does the fiscal framework on its own, without anything else, have in terms of yielding an increase in that? And the submission is that the statement made by the minister on the 12th of March obviously predated any parliamentary processes. But if the court is to have regard to Annexure DA4, let me start here by asking that the court have regard to 02-17, where the DA says, after explaining this process, a copy of the draft rates and monetary amounts and amendment revenue dated 12 March is attached as DA4. Clause 5 amends 71 of the VAT Act to provide for the 15.5%, which is deemed to have come into operation on the 1st of May. And if the court then has regard to that document at 02-64, and can I have the court return to 02-65? And when one looks at the long title, it says, fourth line down, to amend the Value Added Tax Act so as to amend rates of tax and to amend Schedule 2 of that Act. And then the court will have regard to 02-67 and 02-68, where the amendments to Section 7 of the VAT Act are in fact effective. And so the submission is, Judge President, it's not an easy answer, but certainly on my reading of it, the Minister makes the statement. The statement then follows as per what Section 7(4) of the VAT Act says it does. But on the facts of this matter, the statement doesn't operate in a vacuum. The statement must be tabled together with the statute. That statute was tabled as a draft or whatever it is on the 12th of March, and it is the statute that gives the teeth to the increase. And so certainly the way in which I have it is that the Minister's statement up until the point at which the statute is adopted then carries the day, and that must be the consequence of 7(4) as it stands, and provided the statute is then carried, or whatever happens with the statute, that would then result in the process.
I know you are abiding on the issue of constitutionality, or rather on the attack against the minister's decision. But I just wanted to ask a question that we've asked to the minister, that if Parliament is not happy with the increase and it imposes or it amends the fiscal framework by introducing its own increase after assuming that the process is followed properly, and then it's tabled, and at the tabling, the adoption of the report is with the amendment to 0.4, which is a number that we debated around. Now, and the minister comes back saying, no, I don't agree. The announcement goes through. Is that what is the situation? What would carry the day?
I must be careful to stay in my lane, but in direct response to the court's question, I would make the submission.
So doesn't that interfere with the broad powers of the legislature? I know that's not your terrain, but now you are the legislature standing there, and so at least you can give us an answer on that issue. Doesn't that constrain the powers of the legislature in this instance?
I do see it as that, Judge President, and I see it in the following way. Section 7(4) of the VAT Act gives effect to the minister's announcement.
Isn't that problematic potentially?
Judge President, you're drawing me into terrain that.
But yeah, as the legislature, I mean, obviously, I know that you haven't prepared on this point because that's not the point that you had.
I would submit that when one is engaging with the challenge of unconstitutionality and a potential overreach of 7(4) as regards the minister's powers, one would have to have careful regard to what the purpose of that power is, what the duration for the exercise of that power is, and what is the effect of that power if there were to be a statute like DA4 that were to be adopted in the scheme of.
I think the second reason why I'm asking the question is based on the fact that if we set aside the resolutions and the reports and we remit it to the committees to start afresh, whether it will have any impact on its own on the decision of the minister.
I wondered about that, Judge President, and the fiscal framework does have relevance to, I think, with sections, if you bear with me for a moment. Sections 9, 10, and 11 of the Money Laws Act. And so it seems to me that it can't operate in this vacuum. So in the Court of Delegation. ask the court's aware, and I drew the court's attention to sections 9, which deals with the division of revenue bill, section 10, which deals with the appropriation bill, and 11, which deals with the passing of revenue bill, section 11A, for instance. And the court will also have regard to 8, 9 of the Act itself, which says any amendments to the division of revenue bill, the revenue bills, or the appropriation bills must be in accordance with the estimates of revenue and expenditure, excluding statutory expenditure, etc., etc.
So they're not all interrelated. Is there not an interrelationship then between the annual budget and the fiscal framework and all these various pieces of?
So part of the difficulty, Justice Savage, is that I don't read the power given to the minister in 7(4) of the VAT Act to be reflective of this interrelationship. I read that as a circumscribed and definitive power given in relation to VAT rate, and I read other processes as in relation to division of revenue, etc. that it would be.
All right, my last question, and then, of course, if my colleagues don't have any, is that I'm just going to the EFF's issue that Parliament had responsibilities beyond what it actually did to engage with the actually revenue proposals and the fiscal framework by the minister, not simply to say, well, that's the minister's role, and and then that's where the constitutional challenge, if I were to put it that way, or that's where the implication of the Bill of Rights is put in. That you can't on the one hand say we are so concerned, but yet just leave it like that and say, well, that's the minister's role.
So I understand, and that was the last item on my list that I intended addressing, so let me deal with it briefly. Judge President, I think, with great respect, it would take a very brave court to reach into the argument that the EFF has presented on that.
Excuse me?
A very brave court to reach into the argument that the EFF has presented on that score. And I say that because this is an urgent court need to determine final relief on an urgent basis. These are manifestly complex issues and questions as to whether substantive equality rights have been breached or not, based on a particular paragraph or an alternative paragraph in a report that has been adopted, I would submit is terrain that stretches too far for it.
But at least the EFS is asking for interim relief, maybe just to correct you on that issue.
And I'm going to come to the way in which the EFS reliefs have been formulated. But what it does require is it does require this court, bearing in mind, and I'm not for a moment suggesting that separation of powers gives us a red flag and the court can never go there. But I'm submitting that on the submissions made to the court, it would certainly take a brave court to engage in whether or not issues of VAT increases are pro-poor, anti-poor, contrary to our notion of substantive equality or any of that. And I'd submit that it's with respect, it's equally unhelpful to engage in the question of substantive irrationality in what the EFF asks this court. And they're complex questions. You know, the one question is this a legality review or is this a pattern? Certainly insofar as what the finance committees have done. If it's a legality review, is substantive irrationality in the way that it's been contended for an appropriate threshold? And I would submit that these, with great respect, are inordinately complex factual issues and inordinately complex legal issues that certainly an urgent court would not to be going. I'm going to then deal briefly with the question of the relief sort.
Can you do that in a few minutes? 2 minutes? 3 minutes? With costs as well.
Let me go just to... I'm going to go first to the DA's relief. Can I ask the court to go to 01-2 And the court will see that what's being challenged by the DA are the resolutions of the NA and the NCOP to accept those reports. And what they're asking is that they implemented. Now, I've already made the submission, and we've made it in our heads document as well. This is not a question of multi-layered decision-making. The principle is overview. The committee had to accept the report, or it had to accept the fiscal framework or amend it. The committee did just that. It accepted it. When it came through to the NA and the NCOP, it wasn't for them, and in spite of the letters from the DA and from the EFF, it wasn't for the NA to question the lawfulness of what has been presented. The NA was entitled to take the report as it was and to look at it and put it to vote. And I submit that ought to be the end of the matter. But in any event, even if
could the NA amend the report?
Certainly not on my reading of the statute, Judge President. And I tell you why. If I look at 8.6, it says, okay, 8.4, the report must have a clear statement, except when amending. Then when amending, the process is governed by 8.5. And then it says, if the report includes amendments to a fiscal framework or revenue proposals, then these are the things that must happen around it. And I accept this clause may be susceptible to a reading that says that's only if the finance committee effect an amendment. But it seems to me that if the insight and input of the minister is required in relation to a finance committee amendment, it certainly ought to be required in relation to an NA or NCOP amendment. And so we submit that simply on Odicrol, our learned friends ought not to come home on the basis of prayer 2. In any event, even when one looks at the processes by the committee, they're by no means a perfect process, but there's been nothing to suggest that any rule, any provision was not followed in the process adopted. And
What is the legal consequence of that report, the legal effect of that report by the committee?
So our learned friends try and shoehorn it into the space of recommendations or investigations that are given in the context of multi-stage decision-making. We submit that it's a report, and it's a report that's been adopted by the finance committees, accepted by the finance committees. It doesn't have any legal effect other than for the acceptance that it's been accepted by. But I'd submit that that's not the threshold in terms of it ought to have been challenged at the earliest stage. Okay. And I've given the references on Magnificent Mile and
But what do you make of the argument by Mr. Bishop that if he would have come to court on that score alone, the argument could have been he's prematurely before court because Parliament hasn't even decided on the report.
Mm. And so, of course, then that would have engaged the debate as to whether or not it is open to Parliament to even amend the report as it comes in. And in any event, there's nothing to prevent the DA from raising that challenge as a frontal attack in this litigation. That's not what they've done. And so that's the submission. The Nico sort out, and then it says someone begins argument, well, you know, everything's before court and you can simply set aside the finance committee's decisions around it. We submit on a case of this scale and implications of this nature. That's not the way in which a challenge ought to operate.
But the EFF have challenged
I'm going to challenge the EFF's challenge now. So the EFF says that they're asking for a suspension of the report pending the finalization of the document. And the court knows full well that suspension relief is in fact appropriate from EFF versus Gordon. And the question is whether or not the case as made out by the EFF falls into the threshold of a just and appropriate. And we've dealt with this at the tail end of our original heads of argument, and our submission is having regard to prospects of success, having regard to consequences for the fiscus. And parties here will try and make the argument that it is actually an irreversible consequence for the fiscus in terms of funding that's lost, in terms of government priorities that will certainly have an knock-on effect. And I would submit, in light of all of that, a suspension order in the terms sought by the EFF ought not to be granted.
Costs, you done?
If your ladyship will be with me. Much of this case has been framed on after-the-fact statements that have been made. And I would submit with great respect to the court's task is to determine whether or not the process that was followed by Parliament was a lawful one, and secondly, whether the resultant report met with the legislative precedent of what we needed to have. Whatever political parties say after the fact in the space of politicking ought to be areas that the court doesn't draw inferences from. And on the question of costs, members of the board, that's something that Parliament will abide. The case law is what it is on it, and we will leave it in God's hands.
All right, thank you.
Those are my submissions. I'm indebted to them.
Thank you, Ms. Pillay. Mr. Bishop,
Yes.
how much time, what agreement have you come to with the EFF? Should we give you 15 minutes each?
I'm going to have 20 minutes.
20 minutes.
And my learned friend is going to have 10.
10 minutes, okay. We'll hold you to that.
Hopefully I'll be less.
Please.
So I wanted to start with an important issue that had the attention of the court and which cuts across both parts of the case, which is how does the fiscal framework affect the minister's announcement to increase the VAT rate under Section 7.4? And so this could come up in two situations. The one is the one the court has been debating. If Parliament had adopted a different VAT rate, the 0.4, what would that have done to the VAT increase? Or if this court sets aside the fiscal framework, but doesn't say anything specifically about the VAT announcement, what would the consequence of that be for the increase in VAT? And our view on this one issue, we agree with the Minister and with Parliament about the effect of Section 7.4. Because the way we read it, the last part of Section 7.4, so this is on page 2 of that bundle, it says that alteration will be effective from a date determined by the Minister in that announcement and continues to apply for a period of 12 months from that date, subject to Parliament passing legislation giving effect to that announcement within that period of 12 months. So our view is that it will come into effect even if the fiscal framework rejected it completely or adopted a different one. It will still come into effect on the date of the announcement. We say that for two reasons. The first is that it permits the Minister to announce a date before the fiscal framework. So he makes the announcement on the 12th of March. He could have said it will come into effect on the 13th of March, long before Parliament will get to the fiscal framework. Nothing in Section 7.4 prohibits him from doing so. It's not linked to the Money Bills Act. And the second reason is because Section 7.4 refers to passing legislation, not just Parliament by resolution accepting, which might fit with the fiscal framework. So your Lordship presiding called it an unhinged power, and we agree with that. We submit that this is part of the reason why Section 7.4 is unconstitutional, because it comes into effect and Parliament cannot stop it except by amending Section 7.1. So that is our view, and that's why we submit we're entitled to the relief we seek against the Minister, because Section 7.4 is unconstitutional, and this permits immediate, irreversible imposition of a tax. But we agree that it would be better if Section 7.4 was linked to the fiscal framework. You'll see in the letter that my attorneys wrote to the Minister of Finance, I think it was on the 18th of March, it's DA6. It appears at page 02-86. that we put this position to the Minister and to the Commissioner. And what we say is, surely, if Parliament rejects the VAT increase in the fiscal framework, obviously you must accept it won't come into effect. We never received an answer to that letter from either the Minister or the Commissioner. But we put that to them. And we said, because substantively, purposively, surely that must be the position. It doesn't make democratic or constitutional sense. But we don't think it is the position, because it's not compatible with the text. And the way to fix the problem is to declare the section unconstitutional, not to give it a reading the text cannot bear. But if we're wrong, and the court is with my learned friend Mr. Kaitobi, and it says that the two are linked, and if the fiscal framework doesn't adopt the VAT increase, then the VAT increase cannot come into effect. Then the hypothetical question the court has been debating about, if Parliament adopted the 0.4%, doesn't arise. What arises is if this court sets aside the adoption of the fiscal framework, either interim or final, but either way, it suspends it or it sets it aside, but it doesn't say anything separate about the VAT increase. What is the consequence? So as I understand Mr. Kaitobi's argument, the consequence would be that because Parliament has not yet accepted the fiscal framework, it cannot come into effect. And we don't think that fits with Section 7.4 because it's not contingent on positive action by Parliament supporting it, and it must be by legislation. But if the court wants to go in that direction, the one submission we would make is on remedy. That it would be very important to be clear about this, and to give a remedy that makes it clear whether or not the VAT increase is going to come into effect. And if the court is going to suspend it, pending what? Pending Part B of the DA's challenge to the constitutionality of Section 7.4, pending reconsideration of the fiscal framework by Parliament, what is it suspended pending? So, of course, my submission is it should be suspended pending the outcome of the challenge to Section 7.4. And I stress that doesn't prohibit Parliament from adopting it. That just stops the Minister's announcement coming into effect. It would still be open to Parliament to pass the bill before it and give effect to the 0.5 increase. And nothing we're asking this court to do will deny Parliament that power. But it'll be pending the outcome of Part B. So I hope that sets out our position with regard to that question of how Section 7.4 operates and interacts. I then want to deal with the Minister. I'm going to spend most of my time with the submissions made by my learned friend, Ms. Sello. I think there were two important concessions that were either made or repeated. The first is in response to questioning from Justice Savage, the concession that this is a revenue-raising mechanism, it's not regulatory. And the other is that as I understood my learned friend's argument, she conceded it is an amendment to Section 7.1. She said at one stage that the announcement, quote, technically amended Section 7.1, and at another point, quote, it has already amended the Act. So that's contrary to what's put up in the answering affidavit and in the heads of argument, that this is not an amendment. But I think the concession was correctly made, because it can be nothing but an amendment. The next point I want to address is an argument made with reference to the first certification judgment that separation of powers is not absolute. And of course, as a general principle, that is correct. But in this particular area, the Constitutional Court has dealt with where the line lies between the legislature and the executive. And here, on taxing power, revenue-raising taxing power, it's drawn a bright line. So in other places, it can be mixed and it can be context-sensitive, but here, the court has drawn the bright line. I then want to deal with the argument that it's not, this is different from casino association or club, because this is not the imposition of a tax, it's just the changing of the rate of tax. And so I've got three reasons that's wrong. The first is that it's inconsistent with casino association, because as I pointed out in my main argument, and this appears at paragraph 14 of the judgment, where the court sets out how the Northwest statute works. And there's one provision, page 22 of our bundle. The relevant provision that gives effect reads, a holder of a license shall be liable to, at such instances as may be prescribed, pay a gambling levy which shall be calculated on such basis and at such rate as may be prescribed. So it imposes the obligation, it shall be liable for a levy. That's in the Act. And then the Act allows the minister to set the rate, which is exactly the same as what we have here. Yes, there is also a percentage in the legislation, but the minister is given unlimited power to change it. He can change it 1 year to 0%, the next year to 16, the next year to 13. It's almost virtually the same as a power to just set the rate. And so it's substantively identical to casino association. So that's the one issue. The second issue is if one looks at the test, the way that the Constitutional Court has framed it, and I refer the court particularly to Shuttleworth at paragraph 42, where the court says, it is the people through their duly elected representatives who, quote, who decide on the taxes that residents must pay. And then it says, an executive government may not impose a tax burden or appropriate public money without due and express consent. So it's not about imposing a new tax. That's never the language that's used. So, oh, well, you can change taxes, but you may not impose an entirely new tax. It's about decide on the taxes residents must pay and the tax burden. And if you're increasing the rate, you're increasing the tax burden, you're changing the tax burden for residents. The final reason that this distinction makes a difference is it's inconsistent with the underlying principle. The principle, the reason the court has established this rule is no taxation without representation. And I think that quote, I think, goes back to the Boston Tea Party, and I think the revolutionary Americans would be quite surprised and said, well, as long as King Charles is not imposing a new tax, you have nothing to complain about. Because he's just increasing the rate, that's fine, as long as he isn't imposing a new tax. People are upset about taxation without representation because they have to contribute more to the common welfare without feeling that they've been heard by their representatives, that their voice has been heard. And that is the case whether it's an increase, a decrease, or a new tax. I then want to deal with, in questioning, I think my learned friend conceded that there's no constitutional court case that supports this position, that we distinguish between changing a tax and imposing a tax. The closest she came was to rely on the judgment of Justice Rogers in New Africa. And there's a part there where he lists various sections, including section 7.4. But as the court pointed out, that reasoning was not adopted by the majority. It's inconsistent with the majority. And you've got to read with Casino Association or Clava that were unanimous and come after New Africa. So really, the judgment of Justice Rogers is interesting, but has no precedential effect. My learned friend then referred to 2 Pioneer Foods cases, and neither of them are relevant at all. What they're about is compelling the Minister of Finance to issue regulations adopting tariffs under the Customs and Excise Act. Neither of them has a challenge to the Constitution. So they're trying to give effect to the delegation power. They're saying, Minister, you must use this power that has been delegated to you. Neither of them have a constitutional challenge to the legality of that delegation to the Minister. So they're completely irrelevant. They don't engage this issue at all. And so in these circumstances where there's clear, recent, repeated constitutional court authority that supports the DA's case, and not a single judgment that supports the Minister's case, we have at least shown reasonable prospects of success in Part B, at a bare minimum. I would say we've shown very strong prospects of success. That brings me to the argument about the meaning of subject to, and the fact that there's some form of parliamentary oversight in the reference to Zanzi and Morowane. So, as I understood the Minister's position, he accepts that until legislation is passed, the announcement will be in effect. That from the date that the Minister chooses, until legislation, the VAT rate will change as the Minister decrees. And there's nothing that can be done about that. It can never be reversed, it can never be changed by Parliament during that period. And so, to the extent there is some oversight, it can only be oversight from that point onward, because it's impossible for Parliament to undo what the Minister does. So that's not really oversight, that's just saying, well, you can stop it at a point, at some point, if you act. But it's not oversight because it doesn't require approval to come into effect. It comes into effect without approval and as we discussed earlier, even contrary to Parliament adopting a fiscal framework excluding it. So even if Parliament expresses its democratic will and says we don't want the increase, it will still come into effect. That's not parliamentary oversight. The argument was then made that Section 4 is constitutional because it affords Parliament the power to stop the increase. Parliament doesn't need Section 7.4 to give it that power. Parliament always has the power. The Constitution gives it the power to change the law. It doesn't need to enact the statute to give itself the power. So it's meaningless to say Section 7.4 gives the Parliament always has the power to change the law. What that really is a concession that what the Minister is doing is lawmaking. Lastly, to deal with the Minister, I want to deal with the issues about the costs or the dangers of suspending the VAT increase. So the one that was mentioned is, if we don't get the 13 billion, that will increase the risk that we'll need to borrow money, might increase the cost of borrowing money. But this is merely asserted in the answering affidavit. It's just stated in one or two paragraphs. No explanation is given, no details at all about how losing just 0.1% of revenue is going to create any real problem for borrowing. And importantly, the argument about the lack of revenue is not a cash flow problem. The Minister doesn't say, we are running out of money in the National Treasury. We need that which we collect monthly. We need that to pay now. I can't pay doctors and teachers next month unless I get that. That's not the argument. There's no fiscal cliff which has to be filled by the immediate collection of that.
When he says there's a deficit.
But it's a yearly deficit. So it's a deficit that's going to occur if we don't collect 13 billion, we spend the amount that he's proposed, and we don't find some other way to collect the 13 billion. By the end of the year, we will run out of money. But he's not saying we're going to run out of money today or on the 2nd of May. That case is never made in the answering affidavit. So there is time to fill the 13 billion rand hole, either by reducing expenditure or finding alternative revenue. And I didn't hear my learned friend to explain why the alternatives that are identified in the committee's report are not viable. And I didn't understand my learned friend to explain why, if Parliament decides to decrease expenditure by 0.1%, that will have catastrophic effects, if Parliament decides to do that. So we submit on the VAT part of the case, we made out the case for suspension, that the harms of allowing the immediate increase on the poor, on the vulnerable, on all South Africans, outweigh significantly any limited financial risk for business. That brings me to Parliament, and I need to correct an error that I made in my submissions earlier, and this is about the Action SA submission, because the problem is there are two final reports on the record. There's the final report that we attach to the founding affidavit, which is FA 13. And that final report refers to a recommendation of the Action SA proposal is couched just as it has recommended that. And then there's the final report that Parliament attaches to its answering affidavit, AA 7.2, which uses the strict condition language. So we were under the impression that our final report was the same as their final report. This difference is not expressly made in the answering affidavit, and I didn't pick it up, so I apologize for the fault. But it seems that the one attached to Parliament's affidavit is actually the final report. And that does have the strict condition language that was the language used by Mr. Beasley in the committee meeting. So that weakens one part of my case, but strengthens the other. It weakens the part of the case about whether what happened in the committee was accurately reflected in the report before Parliament. Because it seems that it was, although there were lots of last-minute changes going on, but ultimately it was accurately reflected. But it strengthens the other part, because what the National Assembly ultimately voted on, and the National Council of Provinces, was a report with the strict condition language. And for all the reasons I gave earlier, acceptance subject to a strict condition can never be a clear statement accepting or amending, because it necessarily means that the acceptance will lapse if the condition is not met.
But now that was changed to recommendation, as I understand.
So it wasn't. So there were two versions of the report after the meeting. The first version of the report after the meeting changed it to recommendation, and that's the one the DA thought was the final report, and we attached to our founding affidavit. There was a subsequent version of that which uses the correct strict condition language, which apparently is the one that actually served before the National Assembly and is attached to the Minister's answering affidavit. So I apologize for that error. I picked it up when Ms. Pillay was arguing. I think that shows the chaotic nature of the process, that you have so many reports flying back and forth, it's difficult to keep track of them. My client didn't know about this later report when we filed this application. But I don't think this significantly affects the case. I'd like to emphasize a point that both Justice Savage and Justice LaFranci made, that Action SAs, but the way you read their proposal reads very differently if they're against the VAT increase. And that's never recorded in the report. So when you read the subject to a strict condition in paragraph 6.32 of the final report, knowing that Action SA is absolutely against the VAT increase, it reads very differently, but that's never recorded in the report. My learned friend also made something of the fact that there was a change from, that Action SA changed it from an amendment to the fiscal framework to a condition, a strict condition, and that this means that, well, it wasn't an amendment. We accept it wasn't an amendment. She's correct. We accept it's not an amendment. The problem is it's also not a clear acceptance, and that's why it's unlawful. And it doesn't matter from our perspective whether it's binding on the minister or not binding on the minister. It at least contemplates the possibility that the fiscal framework will be amended by Parliament. And that is enough to render it inconsistent with Section 8.4. And I just my learned friend to correctly concede that if the minister comes back with alternative proposals, it will require Parliament to amend the fiscal framework in order to give effect to those proposals. So how can the fiscal framework serve its purpose of guiding the legislation that's before Parliament, serving as the guardrails within which they must appropriate and raise revenue, if, as Parliament itself accepts, it might change? The last point on the question of whether we had to challenge the committees. I understood my learned friend to concede that the committee's reports had no legal effect. If they had no legal effect, then Odacrol doesn't apply to them. They don't have to be set aside because they have no legal effect. There's nothing to set aside. And that's exactly why they are part of a multi-stage decision-making process. It's a report to whom? A report to the National Assembly about what its sub-organ, the committee, recommends it should do. And it is only when the National Assembly or the National Council of Provinces adopts the report, which must have a clear statement accepted in the fiscal framework, that Parliament adopts the fiscal framework. And that has the legal effect of triggering the next step in the budget process.
Can Parliament amend it, the report?
Yes, it can. Parliament can always amend reports of its committees. And Parliament could also have sent it back to the committee. Parliament, it can do that all the time. Committees are part of Parliament, they're not some separate entity. So its choice was not accept or reject, because what happens if it rejects the committee's report? What then? Rejection means we're going to send it back to you. So it could either change it itself and adopt its own version, or it could send it back to the committee and say, we don't think this has a clear statement. Please amend it, come back with a clear statement that we can vote on.
Okay. All right, your time is up, Mr. Bishop. Yes, is there anything that is really pressing?
No, those are my submissions.
Okay, thank you so much. Mr. Mugaitobi.
Thank you, Madam. I have 5 topics, but I will be very, very brief on all of them. The first is just to explain the minister's deception, which hasn't actually been answered. despite the attempts. So the problem with the minister is that he, in paragraph 81, and that's the paragraph they rely upon, sorry, 80.1, which is at 0345. So he first refers to what the EFF says at paragraph 99 to 100. Because he says the EFF says that my decision was unconstitutional because I acted with deception and dishonesty. The basis for this appears to be an accusation that I gave the public the impression that the VAT rate increase could still change, even though I allegedly knew it would not. The submission is unsupported. And then he says, with respect, this allegation is both unsupported by any evidence and difficult to follow. This is what he then says. I have never suggested that I could revoke the announcement at will, nor have I misled the public. From the outset of my announcement, the National Treasurer, SARS, and I have consistently and publicly stated that the VAT rate will increase to 15.5% on 1 March 2025. That remains my position. So that's the first element of the deception. He says in his affidavit, I've never told you that this would be subject to a change. From the beginning up until now, I always told you it would be increased. The problem with that is that it cannot be squared up with paragraph 47.1, 47.2, 47.3, 47.4, which is what the EFF says he told Arthur Trollope, particularly at paragraph 47.3, where Arthur Trollope says in a text message with the minister, the latter says to him, I imagine he will be able to come up with proposals to replace the revenue proposals. So rather than dispensing with the allegation of deception, paragraph 80.1 and 80.2 and 80.3 simply prove the deception. So the minister, I'm afraid, has been deceptive. Why? This is part of the duty of the court, is to call out the deceptions. The second point goes to the irregularities in the process. The irregularities are much more severe than I originally made. The final version that was put before Parliament, the DA said it was Annexa 13, but it turns out not to be Annexa 13, it's Annexa 7.42. But the last paragraph of that shows the problem, because the last paragraph of what is contained in the Parliament's report is not reflected as an Action SA proposal. It's reflected as a committee proposal. So the committee adopted it word for word. And the last part of it says, furthermore, the committee recommends that the alternative revenue proposals and expenditure savings to balance the 28 billion shortfall. Then it says, which must effectively suspend the proposed increase, be finalized and submitted by the committee to process within 30 days for consideration and adoption of this report by the House. So they themselves say these revenue proposals must effectively suspend the proposed increase.
Which page are you on in the report?
That's a good question. 05366 and 05367. So the paragraph of that report, that's the final report that went to Parliament, is 6.33. So they themselves said these revenue proposals must effectively suspend the proposed increases. So that too was deceptive, because it lied to the public by creating the impression that this VAT rate increase is subject to change. Now we have a speaker who says that it is never subject to change. We had a minister who said it was never subject to change. And they simply cannot answer the problem. So both the minister and Parliament have in fact misled the public. Then there is the problem. I know, Madam Justice presiding, you debated with me whether this is deception or shows confusion. And I suggested to your ladyship, if it's not deceptive, it shows confusion. Either way, I come home because it's fundamentally irrational. Then the third point is around substantive equality. I actually agree with Ms. Pillay that it would not be possible for the court in these proceedings to do the equality balancing exercise that I am arguing. But the point is not that you should do the exercise yourselves. The point is that it is common cause that Parliament did not engage with the substantive equality problems that its own report identified. And it did not identify it in one paragraph, it identified it in 6 paragraphs. So she's wrong there in saying it was 1 paragraph, it's 6 paragraphs. And they never responded to any of them. There was one response which was 0 rating, but they themselves explained why 0 rating was not possible. So what you can say, which is not complex, which is not novel, is that where Parliament is faced with a substantive constitutional problem, it has a duty of engaging with it at the very least to avoid substantive irrationality. Then the last point is remedy. The only thing I want to suggest insofar as remedy is concerned is, firstly, I don't have the problem of not challenging Parliament's decision. I've challenged both of them. I would like both of them to be suspended. But if the interdict that I said in paragraph 5 is to be considered, it has to be clear that it includes the VAT rate increase. The last thing we want is for the public not to know what the consequences of a judgment by this court are. Thank you.
What should the argument, Mr. Nkato, be that the committee decision had no legal effect?
Well, I don't think it is a correct argument because Section 8 creates the committee as a separate body that makes its own decision that have legal effect independently of the parliamentary process. And it gives it unique powers. It's not a subcommittee of Parliament, it's a statutorily formulated body.
What is the legal effect?
Well, the legal effect is that when it goes to Parliament with its report, and the report is unlawful, and Parliament acts on the basis of an unlawful report, it would, if it influences Parliament to act, then you could set aside the decision of Parliament on the basis that the basis on which they acted was an illegally adopted a subcommittee report. But does it have legal effect to the public as a whole? I would submit it does, because those committees, what they do, this is the engine of the budgeting process, because this is where they evaluate the submissions we make. They recorded 48 of the submissions, and they evaluated each and every one of them. They are the ones who told us that out of that 48, only 2 supported the VAT increase. It was PwC and PEP. Everyone else objected to the VAT increase. They also have the power, by the way, over the minister. And that's absolutely important, because if you look at Section 8(6), it explains when the report has been amended, what happens. When the report has been amended, it comes back, because the minister is given 2 days to make amendments and then come back to Parliament. So they have power even over the minister when they have made an amendment. And that actually becomes crucial, justices, because if the effect of what Action SA did was an amendment, then it was wrong for it to serve in Parliament, because it should have gone back to the committee for recalibration and redeliberation. But the reason it went through is because they actually never had any genuine intention of engaging with this. Thank you.
So you're saying because of the effective amendment, it should have gone to the minister first.
Yes.
And the minister responds, and then that response is debated and discussed, and then it goes back to the committee before it goes to...
That's the 2-day response.
That's the 2-day response. But the reason it didn't go is what Justice Savage was saying, which is this was a scheme. They never really had any intention of debating any of these things. What they did, they got Action SA naively to go with them. And once they procured that vote, then they decided, let's run this thing through. Now, there is a fundamental problem with this. Public power should not be procured by deceptive means. If a parliamentarian had been bribed in order to secure their vote, that invalidates the vote. That applies equally to a vote that's procured through deception. So the section says 8.6. If the report includes amendments to the fiscal framework or revenue proposals, amendments to the revenue proposals must comply with section 11.3 of this Act. The minister must be given at least 2 days to respond to the report and any proposed amendments prior to the submission of the respective reports to the House. And C, the respective reports of the Committee on Finance must include the responses of the minister. So you now have a 3-stage. Minister responds, goes back to the committee, and then it goes back to Parliament.
Okay. I just want to ask this last question from my side. You said that you agree with Ms. Pillay that it's not the court that has to engage with the test of whether or not that increase should have been done or not, should have been effected or not. But what you're asking is that the court should look at the duty that Parliament had to engage with this issue. Is that the case that's been pleaded by the EFF?
Yes, in fact we argued it, not just pleaded it.
Okay.
But it's certainly the case, both pleaded and certainly in the founding and in the reply, we complained a lot about sort of Parliament's poo-pooing of the equality programs that is created. But in the reply we even attached a full paper by a learned person from the EFF who's an economist. And we argued it fully in the papers, but it's split.
All right, we're just going to ask for a few minutes. We're just going to adjourn for just 2 minutes, and we'll come back just now. Court adjourns. The manner in which you have assisted the court with your Thanks.